Good evening, chat. Welcome. Hope you guys are all doing well. We are going to get started on. Did I touch on the missing mother yet? You're talking about Savannah Guthrie's mom? No, that'll be tomorrow night. Apparently, there is some information there, but we'll get to it. But anyways, guys, we are going to get started here. We are going to cover the case of Wolford versus Lopez. Now, this is a case that they argued a couple days ago, or actually probably a week and a half ago. Remember, we're in the middle of Brandon Banfield, which at times totally became worth the content. It totally became worth the content. But as things turned out, this is a challenge to gun laws in the state of Hawaii. Now, this one's a little more limited in scope as far as what's going to happen here and what this will ultimately turn into. And that's just because this is all about the state of Hawaii. In Hawaii currently, if you have a license to carry a concealed handgun, which is really hard to get, it's like guns are tough in Hawaii already to start with. They have an assault weapons ban. They have a lot of things. It's like worse than California. Now, how does it work though if you have one? Okay, well, Hawaii in their wisdom passed a law. The legislature passed a law saying all private property is prohibited from, you can't carry on private property. You're prohibited unless the private property owner invites you onto the property to do so. Now, that's really the inverse of everywhere else in America. Everywhere else in America, it's the idea that if I'm the property owner and I don't want you, oh, wow, that's neat because it notices now. If you're invited, like if I'm a property owner in Ohio and I don't want you to carry a gun on my property, I have to put up a sign saying no guns allowed. Hawaii does the other way. And it's been deemed by various gun rights activists and people writing about it. It's called the vampire rule because just like a vampire cannot come into your house unless you invite him in. If you don't invite a vampire in, he can't kill you. So that's why when you see vampire movies, they're always like, may I come in? And if you let him in, then they're going to kill you. So that's what we're dealing with here. And whether or not this is legal and whether or not this is an acceptable infringement on the Second Amendment. So while this has already happened, and I know some of the memes have already come out about it, this is actually going to be really good. I think we'll get a lot out of this clip tonight, chat.
It just don't make no sense.
It just don't. So I think that'll be great for us to go here. And why do the Jannies have shields instead of wrenches? That's a YouTube thing. I don't know. Yes, let us commemorate the Treaty of Guadalupe Hidalgo submitting the U.S. victory over Mexico. I know. Not only did we kick their ass, but we also paid them for the land we took, which is really weird. That normally doesn't happen, but yeah. So we are going to get started here, but first we do have a guest joining us. Kurt. What's up, Kurt? How you doing, man?
I'm doing reasonably well. How are you, man?
I'm doing all right. So you were already streaming earlier today. So
yes.
I got the chance to listen to you while I was driving around.
So. I heard we're going to do some Supreme Court, and we're doing Second Amendment Supreme Court at that. So I'm here for it.
Yeah, so this will be a good one. This will be good. And I think you heard me talking about it. Have you, did you know anything else about this before we got started at all or no?
Basic fact pattern. I'm aware of the basics, seen the clips.
Yeah, and if you weren't aware, Hawaii is vehemently anti-Second Amendment.
I picked up on that.
Yeah, and this is one of many cases they've been dealing with. And it also doesn't help that they're in the Ninth Circuit. The Ninth Circuit is massively anti-gun as well. You guys are familiar with what's going on with all the stuff out of California. Anytime a judge rules in their favor, the Ninth Circuit hears it en banc, and then they shoot it down. So it's really tough to get out of this, but we're gonna see some good stuff here. Tejas Libera says Hawaii does not have a assault weapons ban. They just have the 2 feature test, which only affects AR pistols and Dracos. Really? I thought they had an assault weapons ban too. Huh. Just no Dracos and no AR. Really? Hold on here. I don't know where you go shoot though in Hawaii. I can't imagine there's. Oh yeah, okay, yeah, you have to register it. Okay, well that's. And no assault pistols. Okay, but they do have a 10-round magazine limit. It looks like in Hawaii, so there are a lot of shitty things in Hawaii. So yeah, looks like. But thank you for correcting me. I appreciate to know that. So Hawaii sucks just a little bit less than California, just a little bit less. Pitch Lux a sad Fudbuster noises. Yes. All right. So, anyways, let's get started, Kurt. Here, you ready to go?
Sure.
All right. I guess something about Oprah. I don't get it. All right. Now, this is the happened about 2 weeks ago.
It regulates arms bearing.
So, guys, if you don't realize this is Alan Beck. He is one of kind of the more prominent Second Amendment practitioners that goes in front of the Supreme Court. So here we go. Here we go.
Conduct. As such, the burden is on Hawaii to justify the presumptive ban with relevantly similar historical analogs reflecting a national historical tradition of firearms regulation. Hawaii comes nowhere close to carrying the burden. Its presumptive ban defies a national tradition of allowing people to carry onto private property open to the public unless the owner objects. Hawaii's threshold position that this court should adopt a state-by-state community standard lacks support in this court's precedent, and Hawaii's argument the laws of the Kingdom of Hawaii should determine petitioner's Second Amendment rights is completely without merit. The presumptive ban is inconsistent with our national historical tradition of firearms regulation. Hawaii attempts to show a national tradition by relying on black codes expressly passed to discriminate against African Americans in anti-poaching laws. These types of laws are nowhere near relevantly similar, because nothing in our nation's historical tradition begins to support Hawaii's effort to thwart the exercise of a fundamental right Hawaii's law cannot stand. I welcome this court's questions.
You argue that this law prevents access to about 97% of public areas. How do you arrive at that?
We're not arguing this specific law is banning 97%, Your Honor. The overall package of laws passed by Act 52 bans, presumptively bans, carry on 96.4%. And we
think about that, guys. If you live in Hawaii, you are banned from carrying a handgun on 96% of the state. That's a lot. That's a lot. So it's not just this law. There's a bunch of different laws Hawaii passed recently. But yeah, this is pretty tough. This is pretty tough. So this is I think they did that to show how ridiculous Hawaii's been so far. But yes, Hawaii is very rough on these things.
Arrive that figure by having an architecture firm go through the public records of the county of Maui to determine which areas were regulated by this package of laws, Your Honor.
So that 94, I think it was 94, 97%.
96.4, Your Honor. Justice.
That includes all the areas the law bans, correct?
Yes, Justice.
I understood that much of Hawaii is state parks and state property, correct?
A portion of it, yes, Justice.
Pretty sizable portion. So that 94 is over-inclusive of private property, correct?
It includes parks and beaches, yes,
All right.
Justice.
Now, and there are other areas, sensitive government areas, et cetera, correct?
That is correct, Justice.
All right. So you say that there is a constitutional right to carry a gun on private property?
Yes, Justice.
I've never seen that right. I mean, I understand that there is a right to carry a gun on private property with an owner's consent, express or implicit, correct?
The Second
My
Amendment,
question is very simple. Is there a constitutional right to enter private property?
I'm going to argue you kind of already stipulated it is, Justice. You said it because if it's implied, well then yes. And Hawaii's implicitly saying no. I mean, I think that seems a little goofy for her to make that argument because she knows what she's she wants to say this is legal and constitutional. I mean, am I wrong, Kurt? I think she didn't artfully phrase that, I guess, is what her defense would be.
Yeah.
So, all right, well, here we go.
With a gun, without an owner's express or implicit consent? The answer has to be simply no. You can't enter an owner's property without their consent, correct? Express or implicit?
correct, because that would be a trespass, Your Honor.
All right. So if we start from there, then I start from the simple proposition. You want to say that there's a custom that permits you to go on private property without the owner's express consent, correct?
Not quite.
Yes, Your Honor.
All right. So
I agree, yeah. not
Justice Scalia said that every statesman at the founding knew that you could not enter private property without permission. It's a trespass, correct?
It is,
Yeah.
you're not allowed to come onto private property that, where you don't have permission to go to.
All right. So if we're looking at a custom,
I mean, yeah, that's basic private property rights. It's the bundle of sticks. And don't laugh, Jack, because that's what they call it in law school. They describe it as a bundle of sticks, a bundle of rights. You can include, exclude, you could sell, lease, do whatever you want with it. So yes, like nobody's questioning that. Nobody's questioning that. So far, at least.
I thought under McKee, Justice Holmes looked for evidence, quote, that a practice had prevailed in Missouri where the suit originated. Whether you could collect shells in Missouri depended on whether there was a custom in that jurisdiction.
Wow. No. Just all the no. Because you're taking
about?
Yeah, because we're dealing with a constitutional right issue.
Mm-hmm.
And so if you're trying to figure out what is the implied license to enter property, then that might be determined by the customs of the area, that what people would allow or would not allow. But this is dealing with a constitutional right, so it's naturally federalized in its consideration.
Yeah.
So I can't speak to the finer points of whether or not it is customarily acceptable to enter someone's private property for the purpose of picking up shells or not. Maybe that is the custom in some place. But since that's not a constitutional right, it feels off point.
Well, she's trying. She's struggling here. Sounds like we're already getting preview of what's going to happen.
Yeah.
McKee holds, Your Honor.
It didn't. It looked at the custom of Missouri where the suit originated.
McKee specifically.
Also, are there a lot of
talks about the
seashells in
laws of the
Missouri?
Well, I think they mean like fossils when they're talking about shells.
Right.
So, or maybe they mean like Velveeta shells and cheese. I don't know. I mean, you can't go to the store and buy them. Who knows?
nation as being what's dispositive.
McKee, Justice Scalia did in Hardeen's, but the McKee, Justice Holmes wasn't talking about the tradition of the nation. He was looking at whether the tradition of Missouri permitted people to go onto land to collect seashells.
I have to disagree. The words nation appears in that. It looks at
All right, well, I'll look at it more closely.
I bet you will.
But at the time of the founding,
It's funny when you're like, normally you're like, no, Judge, you're completely fucking wrong. And she's like, I'll go look at it later. It's like, you won't, though. She's going to completely forget about it.
or about the time, 71, 1721, 1722, up until the founding, there were at least 3 states who prohibited hunting, as you called it, or trespassing on private property with a gun, correct? So there was not a uniform national practice.
There was, Your Honor, of carrying on private property that's open to the public. Every case that every law that you're citing to deals with prohibitions on enclosed lands. And enclosed lands, there was those laws deal with, the enclosed lands were closed to the public.
Not necessarily. Look at Mount Vernon, where George Washington lived. There was a county shop there.
By definition, if
That's a closed land.
Enclosed
Is it though?
lands, I'd reference the
Doesn't sound very
amicus
close
brief
to
of the
me.
United States. They reference a law review article by Sigmund, and it goes into express detail that enclosed lands are.
Yeah, can you
were
stop, because
closed to the
I don't want the
public.
I don't
Counsel, do you
want
agree, picking up on that?
I don't want to let
that
the point
Hawaii,
go by. I mean, that strikes me as odd. Okay, Mount Vernon, obviously in the first instance, is George Washington's home, so it's private property,
Yes.
so he can control it. But if you're telling me that he allowed to be installed on his property a county shop, that's the premise, right? It's a county shop now.
Yes,
Well,
the government, yes.
Then that would imply, because I need to be able to get to the county shop, that would imply a license to access his land for the
Yes,
purpose
and for the
of
public.
accessing the shop.
Yes. Yeah, like how would you
It's
use
like
it?
an implied easement.
Yeah.
So what are we talking about? So yeah,
They just don't want to have to admit.
Mount Vernon
okay,
had a
yeah.
county shop. It's like, okay, if you're telling me George Washington allowed a county shop to be installed, and so people can now visit the county shop, well, it's open at least to the extent they visit the county shop now, isn't it?
At least to that portion.
What are we
of
talking about?
Mount Vernon, yeah.
Yeah.
They are struggle busing because they don't want to say, yeah, you're right. They have to say no because it's guns. So
could pass a law that prohibited the carry without the express consent of the owner on lands that were closed to the public, on private residences?
I do not, Your Honor.
Really? Like, so I couldn't, Hawaii can't have that law about, my house or Justice Gorsuch's house?
Step one of the plain text would be implicated because we're talking about carry. And then Hawaii would need to justify that with a national tradition. And even assuming the three laws, I don't think three laws is sufficient to demonstrate a national tradition. So
but do you agree that all of the business owners and maybe also private property owners in Hawaii could get together and say, we don't want this, and they could not give consent? Let's say the law is flipped. It says it's illegal to enter if you have been denied permission to carry a gun on the property. You agree that all property owners could get together and say, we're denying permission, and they could put such placards up in their window, and then you would still not be able to carry a gun on 97% of the property in Hawaii?
Yes, Justice. Every private property owner has the right to affirmatively put up a sign or otherwise not give permission for people to enter property with a firearm. The crux of our argument is that Hawaii has flipped that historical default from them having to affirmatively say guns are not allowed here to the current law.
But I guess my question is, isn't that historical default that you're referencing really a default that is rooted in property law and not constitutional law, not in the Second Amendment? I mean, the argument that some have put forward is that this is really a property case, not a Second Amendment case. Yes, it is about guns, but the argument goes, what's really going on here is how states treat a private property owner's consent under circumstances in which everyone agrees that consent is required. You just agreed that consent is required. And so
Tectone, Destiny, Turkey Tom, Miskiff, all start please taking notes. Consent. Yes, it's very critical.
fine, there are many states, and perhaps even most states, that say we're going to imply that a property owner who opens his property to the public is giving consent for people to carry a gun. Hawaii has said, no, what we're going to do is we're going to say, even if you've opened your property up to the public, you still have to have express consent. We are not going to make our property owners put up signs or be the one that has to affirmatively express. The person who comes on has to have consent, as everybody agreed, and in Hawaii, that consent is expressed. Why isn't that and all the cases that speak to it in the historical record really about the property interests and property rights and not about the Second Amendment?
Because here the law at issue implicates arms-bearing conduct, Your Honor.
But that doesn't mean it implicates. What I'm suggesting is that it might affect, right? And the United States was here just last term talking about how you could have rights and regulations that affect someone's interests, but they actually don't implicate their constitutional rights. And so here I'm saying, yes, gun owners are going to be affected because the property owner says, no, I don't want you to bring your gun on unless you come to me and I give you express consent. But that doesn't mean it implicates their Second Amendment rights for the purpose of Bruin.
Well, in Bruin, the court said that there's a general right to carry.
A general right to carry on public property.
No.
Justice Barrett just explored with you the fact that you don't have a general right to carry on private property.
It's a right to carry in public, Your Honor, and not
Right.
a right to carry on public property.
But you do agree that there is no right to carry on private property without the owner's consent, right?
Here, the Second Amendment is implicated, especially when you anywhere you carry in public. And here, this lawsuit, it deals with private property that's open to the public.
I understand, but what I'm suggesting is that let's
Wow, that's a first for her. I didn't know she could say that word in that way.
suppose this lawsuit dealt with someone's house and it's not open to the public. Do you concede that there is no Second Amendment right to carry a gun into someone else's house?
I do not, Your Honor.
You do not
I do not. You still be dealing with carry. If someone gives me an invitation, a general invitation to enter into their home, and there's a historical presumption that you're allowed to carry a firearm with you, then if the government passes a law that says, that flips that historical presumption.
Right, but I'm just suggesting that the historical presumption is about the consent, not about your rights. We agreed at the beginning, I thought.
Now, I think she's trying to get around this by saying, can you just carry guns into people's homes? And she's struggling because she's not even focusing on the fact there's a law anymore. She's just saying, just traditionally, could you do it? Is it proper practice? I think because she realized it's going to sound goofy for the government saying what you can't do on someone's private property like that. I don't know. I think they're really trying to avoid having to admit this is a bad law.
I thought there was a general consensus that your right to carry is limited to the permission of the owner when you're talking about private property. Like you've already agreed that the Second Amendment right is I would say subordinate, but in the panoply of rights, the right to exclude is superior because the owner can say, no, you can't bring this gun in here. And so once you've done that, these laws that are about licensing or, implying that the owner has consented are all in the realm of property law, I think, and not in the realm of the Second Amendment anymore.
I don't see it that way.
You disagree? All right.
Yes, Your Honor.
Thank you.
Counsel, do you agree that the state as property owner could exclude someone, not this implied consent law, but let's say that the state as property owner, put aside the fact that the sensitive places here include state-owned property. Assume that that's not so. Could the state as a property owner say that you can't carry a gun onto state-owned property as a matter of consent under property law?
No, Your Honor. I think that's a different analysis because now we're dealing with direct state action.
And the state doesn't have the right as a property owner to limit who carries a gun, say, into the governor's mansion?
I think that there are certain locations that where...
So it's all a matter of sensitive place?
Yes, Your Honor.
Counsel, you make an argument that Hawaii effectively destroys the right to bear arms. You discussed that a little bit with Justice Thomas and with Justice Sotomayor. And I'm wondering where you think that analysis fits into the two-step Bruin framework the court announced.
In this case, step one merely deals with the fact that the state of Hawaii, that carry is implicated here. And once we go to once we accept that carry is bearing a arm is at issue here, everything else is dealt with under step two, the historical analysis portion of this analysis, Your Honor.
So it really doesn't matter whether it was actually 96%, which we know it's not, because you're dealing with the law as a whole. There's no means and scrutiny permitted by Bruin, correct?
Interest balancing has been abrogated by yes.
By Bruin.
Yes, you're not allowed to do that. I don't know why she's asking that question, because it's like, you were here when that was written, Sonia. I like, no, we forgot what was in there. Are you trying, like, why would you? I wonder if she was hoping he'd say no. I just like you were here when that shit was written, girl. I don't. They're very docile and they're being very obtuse.
So there's no interest bearing. So if in fact, if Hawaii has a right to regulate a custom as opposed to a constitutional right to bear an arm on private property, then tough luck, correct?
We have established in our briefing, Your Honor.
Counsel, there's no means ends. So if they overregulate or underregulate, that's irrelevant. Is there a right to carry a gun?
As we know from Rahimi, there's a general principle that dictates that you have a general right to carry. When the government violates that rights, then because it violates that principle, then the second...
That's the interesting part. There certainly was a principle of the states regulating hunting on private and closed property. There was a history of, in at least New York, yeah,
there's a tradition of enforcing hunting because you were hunting the king's deer. You know, you weren't allowed to hunt. Hunting was very much like in Europe, hunting was frowned upon. You know, in Europe, it's the sport of the elites. And even here in America, yes, the hunting regulations are you're killing the king's deer. So I don't know where she's going with this. This is I don't know. I don't know here. So, because generally speaking, in America, there wasn't a prohibition at the time of the founding. Like you hunted, at least, you know. So I understand it. So let's see.
1763, just before the founding, that prohibited trespassing and hunting on other people's lands because trampling on the land was destroying it. So you don't need, under Rahimi, an exact duplicate historically. You just need an analogous principle. If the states could regulate there, why can't they regulate here?
Well, very simply, those laws deal with just are not anywhere close to.
Well, number one, even if there wasn't a law against it, you have common law right in court to sue for trespass and to sue for damage and to sue for conversion. So like I don't. God, they are trying. They're trying to sound retarded today. In this is ridiculous. This is absolutely ridiculous here. I just she's not being very wise tonight.
Yeah, not this issue.
No.
The Supreme Court, I'll tell you one thing. I was happy that the Supreme Court took like 2 Second Amendment cases this year. That was great. Well, the Supreme Court just needs to take more Second Amendment cases. They take 3, 5 First Amendment cases every single year.
Well,
I just need to take more Second Amendment cases.
I've said this a couple of times, and it's actually one of the few times that Robert Barnes actually agreed with me. The way the Second Amendment stuff is going to go is like the civil rights cases. We didn't get to where we are now all of a sudden.
Right.
It took decades of cases and decades of cases and decades of cases to get to this point. So it's going to take a while.
Well, this is what I'm saying. This is my
Yeah.
point. I think that if I were trying to map this out, I'd try to find some low-hanging fruit, some relatively non-controversial Second Amendment cases in the broader scheme of things, try to build up a base of cases to give myself some things to work from
and
for
this
the
is a great
future.
example of it.
So, if I were God of the Supreme Court, I'd find 3 to 5 kind of like relatively low level Second Amendment cases that, won't be as controversial, so that I can start building some case law so that I have some things to work from in the future.
Yes.
That'd be great.
Yeah, and this is a good one. This is a good one here.
And then they're going to take the case dealing with drug users.
Yes.
And which surprised me that they would take it. I figured they'd take it eventually. It surprised me they took it this term, but cool.
I'm not. I know what they're going to say. Nope, no guns for you. And it's also like,
you think so?
Oh yeah.
Okay.
Like here's my point, and we're gonna rewind back to here. Okay. We're at 16-minute mark, but we're gonna use these people here. You are not like, I want machine guns. No. They're gonna say no. They're gonna say no. For the record, I'm not talking about murdering all these people, but who else is gonna say no? She's not gonna let you have machine guns. You think she's gonna let me have a machine gun? You think he's going to let me have a machine gun? No.
Gorsuch might let you do it. Roberts won't.
Yeah, he's not going to. Alito had the nickname Machine Gun Sammy back in the day because he wrote a Fifth Circuit opinion where he was like, it's okay. Like, I'm not opposed to it. So he got known as Machine Gun Sammy. So, but even like, so yeah, maybe. And Clarence Thomas, I'm kind of thinking maybe. So you've got 7-2, no, with two, yeah.
Well, that's why this is like the frog pot thing. We need to work their way up with smaller cases. So
yeah, but I think most federal judges, by the time we get to
machine gun, maybe
yeah, but I think most federal judges ain't gonna do it. So, Barlow says not if they don't allow you to do it. Correct, but if you'd like to do it without having to worry about feds trying to kill you, these are the people you need to talk to. So. Lars Larson says Clarence wants us to have weed and machine guns. Shout out Sea Dog. Maybe. I don't know. I don't have faith, chat. I think that's the one thing we're never gonna get. Like, we'll have a right to an N-word pass before we get machine guns.
Ouch.
So I think. So here we go.
The law issue here. The state has pointed to a number of anti-poaching laws on property that was not open to the public, whereas here they're regulating a specific type of carry for self-defense on private property open to the public. I mean, these laws are just simply not.
What's open to the public and the license that you have to use that land is subject to custom.
It's subject to a national tradition that we had at the time of the founding, Your Honor. It's not, a specific custom that exists right now.
If means and ends is not a part of our equation, I don't understand what pertinence that has.
Because in order to do the Bruin analysis, we look to see whether a law is implicated by the Second Amendment right. Then we look to see what the historical tradition was in this country.
But that seems, I'm sorry. If you could regulate to not trespass, trample the ground, if you could regulate not to hunt, if it's not means and ends, why can't you regulate simply to switch a presumption that gives the owner the right it has to give you express consent to say yay or nay to carrying the gun?
Well, for two reasons, because that violates our nation's historical tradition of firearms carry, and two, it violates a principle that.
But we didn't have.
Also, I see that your red light is on.
Yeah, yes, Your Honor.
We've been talking about private property and public property. A gas station on the side of the highway is private property. It's owned by the gas company or whatever. Do you assume that you have the right to go on that private property even without any express permission,
Yes, Your Honor.
even though it's private property?
Yes, absolutely, Your Honor.
Is it a different analysis or the same analysis when you're talking about a dwelling along the side of the of a road?
That's a different analysis, Your Honor. You have to see whether there's some sort of invitation to come in there.
Is there, under our law, an invitation, for example, for people soliciting, for people who want to drop off pamphlets about a particular?
Yes, Your Honor. Up to the doorknob or the car, there is.
Even though it's private property?
Yes,
A stranger can walk off the sidewalk and go up to the door?
Yes, up to the door, Your Honor.
Thank you. Justice Thomas?
I mean, yeah.
Justice Alito?
Under Hawaii.
I mean, why, like, I mean, that said, though, if, like, the homeowner says, get off my property, you're not allowed to carry a gun on it, guess what? Can't carry a gun on the property. But yes, until you're told no, I think that makes sense. So, it's being too difficult about this. Real quick, Tejas Liver is a new member, and he says, thanks for getting me deported. I had to pay to get my green card to come back. No, sorry. You guys are talking about Alan Beck. Guys, Alan Beck has done a lot of Second Amendment law, especially out in the Ninth Circuit. He's been doing God's work out there. So, yeah. And then real quick, we're going to get this out of the way because it did pop up here. Stephen Cooper for 20 subs. Let's fucking go, chat. Let's go. Although we just saw Clyde, we are going to I'll get a no woo for that, chat. So thank you, Cooper. Thank you, Steve, for your generosity and your support. And then real quick, Roscoe's asking about Ohio law. Does Ohio still have disclose when you get pulled over? Yeah, you got to tell them. That is a problem here in Ohio. That is still a thing here. You can get charged for that. And does the 7-month or 7-year rule? I don't know what you mean by that, but yes, we do still have that. So that still is a thing. Sadly, it is. Let's keep going here.
Law. Are there any other objects besides guns that a person may not possess when that person enters private property that is open to the public?
Not to my knowledge, Your Honor.
Thank you.
Justice Sotomayor?
In Hawaii for 200 years, there's been no custom of carrying weapons, correct?
That is a disingenuous question.
Up until Bruin and...
I mean, yeah, because, like, well, no, they were doing it in Hawaii. Yeah, what were they carrying? Spears? Like, I'm sure they did that. And then there's the spirit of aloha and all that retarded crap they try to push.
For a lot of that time, they were a kingdom.
Yes, they were an absolute monarchy. Like, I'm not sure it was any better. And yes, the Hawaiian monarchy was really bad, from what I understand. It wasn't like they were all just like, hala, hala, hala. You know, like, it was pretty bad at times. So, Tejas is saying it's pronounced Libre. I thought it was Liber. I thought it was like Diopresso Liber, or not Libre. Okay. You snowman. Thank you. My whiteness. Oh, yes, they still have that. Well, remember, you don't. Okay, I remember what you're saying. Yes. If you want to get a license, yes, but remember, you don't need a license to carry a firearm in the state of Ohio. You can just merely do it.
Based.
So, yeah. Yes. Cuba Libre. Yes. Correct. But yes, when did you stop beating your wife? That's what she just asked. Yes.
Heller.
Up until
Can't stop,
Bruin,
won't
you could not get a license to carry a firearm, Your Honor.
So 78% of Hawaii residents and 64% of Hawaii gun owners do not think that loaded concealed weapons should be allowed into businesses at all, correct?
I'm unaware of that statistic, Your Honor.
I wasn't aware of your 96% number either.
What the fuck is that passive
Nothing
aggressive
about
comment?
Hawaii's custom.
That comment matches her face right now.
We're trading insults now?
Yes, it's like a little fucking Reddit response. Meow. Yes. And then, yes, it is funny because the Hawaii's flag incorporates the British flag. It does.
For no particular reason.
Well, I think they had some British influence when they were called the Sandwich Islands. So here we go.
Tradition or culture creates an expectation
Speed this up just
that the general public carries guns wherever they go, correct?
Hawaii is part of the United States, and as part of the United States,
It's
national
our culture.
tradition is that people are allowed to carry on private property that's open to the public.
This law is not banning you from doing that. It's just requiring you to get the owner's permission, correct?
And here, the law has always been that you had an implied right to enter onto
Not in
property.
Hawaii.
Not in Hawaii.
As- Hawaii is part of the United States, Your Honor.
Thank
And
you.
As
But if it's a
Thank you,
local
Alan.
custom that controls.
Yes, Sonia, yes. In Hawaii, they probably did human fucking sacrifices. Does that mean that's now part of Hawaii's culture and tradition as far as laws go? That, hey, we could throw fucking virgins in the volcano?
Sonia Sotomayor, part of the team that doesn't think Hawaii should be part of the United States.
Yes. Does Sonia
she wants to
Sotomayor
expel
now
it from the
believe in
Union?
secession? I think we're there, chat. I think she answered the question. She's overruling the Texas case. You can leave, apparently.
There you go.
But yes, they did all kinds of shit in Hawaii. In Alaska, they'd shove old people out onto ice floes. I guess euthanasia's okay then. It's a tradition of it. So yeah, I'm sure they had slaves too. Yes.
No, of course they
She's
didn't.
not that dumb, is she? I mean, she's supposedly wise. But we don't know.
I mean, compared to Jackson,
Yes.
Rhodes Scholar.
Yes, I know but that's when you figure competition there. Yeah. LCW Archive says Bruin doesn't test your tradition in the individual state, though, right?
No.
Yes. I mean, like, you can draw on the states in total, but they can't just say, what did Hawaii do in only Hawaii? That is correct, but like they could say, what did Wisconsin do? What did, really, well, actually at the founding, they weren't around, but what do the 13 colonies do? And you could kind of pick and choose from there. But you can't just say Hawaii and therefore that's it. So yes, you're correct in that regard. Let's see here. What was this? Sean Sandwich Sundry for $2. Did someone say sandwich? Yes. Does she have security that carries? Yes, Kathy. She has a team of United States Marshals who are part of her protective detail. And anytime she goes around the country and goes and speaks at law schools or anywhere she goes, they follow her around everywhere she goes.
It's not a local custom that controls. It is the
Where
custom.
else in the law have we permitted local custom to create a constitutionally protected right?
Bruin was very clear here that we're dealing with our national tradition, Your Honor.
Yeah, there you
It's
go.
not
Thank
local
you,
custom
Alan.
that
Yes, and that's the point.
It's not the local tradition. It's the
Yeah,
it's the
and it's the national
tradition.
tradition. It's like, what were we doing in the country? What were the states doing? Like, what were they doing?
When they wrote Second Amendment, what was meant to protect, and then that's everywhere.
Mhm. Yeah, but also we could say, what did they do in New England? What did they do in the South? But yes, just saying, oh well, if we're in Georgia, we can only look back through the history of Georgia. It's like, well, how would that work? Like, some of these places were sparsely populated throughout history until now. So.
controls in this area of law.
Justice Kagan?
Mr. Beck, the various statutes that Hawaii has cited as going to the Bruin Step 2 question, you say they're not close enough. And I guess I want to know why. I was struck by the fact that there are quite a number of statutes that do exactly what this law does. They flip a default rule as to how explicit consent has to be. They recognize that You don't have a right to go in without consent. You do have a right to go in with consent. And then the question is, how do we determine consent? And what default rule do we start with? And I guess what struck me about these statutes and about how close they are is that that's exactly what each of these statutes did. So why isn't that pretty good evidence under Bruin Step 2 that this is something that states historically have done?
The state is not cited to a single case that is relevantly similar to the one at issue here. We've got basically two sets of laws. One with anti-poaching laws that dealt with private property that was not open to the public, one. And part of that also is there are exemptions for people to be able to carry firearms onto those lands that for purposes of self-defense. So land that's...
Yeah, I'm not carrying a Glock 19 to go deer hunting. I'm carrying it for self-defense. So, yeah. Good job by Ellen Beck there. Very good job.
Not open to the public, where you still have a self-defense right, isn't relevantly similar to the law at issue here. And the other sets of laws that have been cited to are black codes. And those can't be relevantly similar. As Justice Kavanaugh said in Rahimi, we've moved away from that history. And in addition, it dealt with a very, discriminating against a very small subsection society rather than prohibitions on the general right to carry.
Yeah, so let me go back to the first thing. The idea that these are anti-poaching laws. I mean, okay, Hawaii's is not an anti-poaching law, but I suppose I'm sort of stuck on the fact that that doesn't seem to be the relevant similarity. In Rahimi, we said, you can go up a level of generality. You don't have to have a historical twin. There can be differences. In Rahimi, the essential similarity that we thought controlled was just that the guns were being used to protect against people who would be violent with their guns. And, that's pretty general principle. And here, the general principle is sort of similar. We think that there's a danger of various injuries occurring when you go onto private property with a gun. It might have been in the old days poaching. It might be something else now. But because that's so, we are going to use a default rule that says to the property owner, if you want this, okay, but you have to say you want it. It seems to me the same. It's a different injury. It's not poaching anymore, but it seems to me the same state mechanism, the same kind of state regulation.
Yes, Your Honor, but one dealt with private property that was not open to the public, whereas this law is dealing with private property that's open to the public. And in addition to that, the anti-poaching laws also gave you a right to be able to carry firearms for self-defense. So I just simply don't see how the level of generality there would simply swallow the rule if the court were to accept those anti-poaching laws as being relevantly similar here, Your Honor.
Thank you.
Justice Gorsuch?
Your friends on the other side in the Ninth Circuit relied on two statutes in particular. One was the 1771 New Jersey law that you were just discussing with Justice Kagan. But the other one that was left unmentioned was an 1865 Louisiana statute that was adopted immediately after the Civil War as part of an effort, it appears, to disarm black people. The Reconstruction governor later explained that this law, of course, was aimed at the freedmen. Do you think the black codes, as they're called, should inform this court's decision-making when trying to discern what is this nation's traditions?
I do not, Your Honor.
Well, your friend on the other side says it should, and that the 1865 statute is a, quote, dead ringer for this statute.
The 1865 law was expressly passed to discriminate against African Americans that were newly freed slaves. And I just don't see how a law like that can be used to be analogized to a modern day law, this modern day law, Your Honor.
Justice Kavanaugh? Justice Barrett?
Do you agree with everything in the government's brief?
No, I do not, Your Honor.
The United States government.
Yes,
Okay.
Your Honor.
The government that's on your same side.
Yes, I understand. I agree
I'm
with
not asking you to throw your case away.
I fully endorse the United States brief, Your Honor.
Okay, and then I just have one clarifying question. When Justice Kagan was pressing you on the analogies between the anti-poaching laws and Hawaii's law, One of the things that you used to distinguish it was that the anti-poaching laws applied to private property, and these applied to property that's open to the public, albeit private. But I thought you had initially told me that Hawaii couldn't do this with respect to property that was like a dwelling, a private residence either, that was not open to the public.
Well, what I'm saying is that that would simply, that's a different historical analysis. And if they were to muster enough historical analysis to justify the law, that might be true. I just don't think that they've developed enough history on this record to be able to justify that law, Your Honor.
Justice Jackson?
The Chief Justice asked you about a gas station on the side of the highway, which is private property. It's open to the public. And you said that we presume that a person can go in under those circumstances. Is that right?
That's correct, Your Honor.
All right. I guess what I'm positing is that the reason we presume that a person can go in is not because they have a constitutional right to go in under the Second Amendment or anything else. The reason we presume they can go in is because property law implies that a gas station owner who has private gas station and opens it to the public has consented for people to come in. So it really is a function of property law and the extent to which the consent is being implied or expressed, and the state law governing that, right? I mean, it's not, you don't have a right to go into private property. You're only there because the owner has either implicitly or expressly consented.
You have a constitutional right to carry your firearm onto that specific gas station.
You do. Where is that? I thought the reason why this was all here and is because you had an implied license. I thought the historical tradition required you to have a license because you don't have a right to go onto private property. And the tradition was we're going to imply that you have a license under these circumstances.
The basis of this lawsuit is that we're only discussing private property where you have a right to enter onto that's open to the public. And we're saying that once that property is open to the public, we have a right to carry a firearm onto it.
Okay.
Unless the government.
Okay, I think I understand. Let me just ask you about the black codes. Justice Gorsuch raised it. And I guess what I'm wondering, your answer to him was they can't be and shouldn't be used. And I guess I want to signal a problem with the Bruin test, that to the extent that we have a test that relates to historical regulation, but all of the history of regulation is not taken into account, I think there might be something wrong with the test. So can you speak to that?
There's nothing wrong with the Bruin test, Your Honor, just on a fundamental level.
Stop. That is stupid on levels that I cannot even begin to fathom. All right. So we talk about the history and tradition of the Second Amendment. Okay. And first of all, with respect to the Second Amendment itself, that's going to be pre-1791, because that would be when the Second Amendment passed. And these black codes were after that. So it's not going to be particularly informative to the Second Amendment. And even with respect to the 14th Amendment, the black codes didn't really come until after that either. They were
there were still laws though on the books back then. You couldn't arm slaves.
Yes, that's true, but the slaves were not considered full citizens.
Yeah, but there were laws though about restricting, but there were clearly laws about we wouldn't let the Indians or slaves possess firearms,
which also weren't considered citizens.
I understand, but it's
so it doesn't quite work because the Second Amendment, at least in my mind, right, it's meant to protect we the people. Who is we the people? Well, at the time, Indians were not considered citizens from birth. That wouldn't happen until what, the 1910s, when they changed it by statute.
Well, no, that was 1924.
Okay,
I helped.
Are you harassing me because I said 1910s? You're like, no, actually, it's 1924.
Yes, because I knew
close.
I knew it.
Unbelievable. Unbelievable. Yeah, so that didn't really work. And obviously the slaves weren't considered full people, so that doesn't really work. Yeah. So I'm not sure how any of this matters. And even if it did matter, like laws that were specifically designed to take away rights from people.
Yes.
So like that doesn't really seem like I cannot believe
we didn't really take anytime we took away your rights is generally because we were gonna hang you. There weren't really many other times your rights were taken away for the most part in colonial America. I mean, that's the thing. Like, there were very few felonies, and you kind of just did your thing for the most part.
I'll remember that 1924 thing.
Yes, called the Peck Act.
Thanks.
I had to help Ryan Mullally get ready for some stuff with
Great.
when he
Thanks.
debated
That's fine.
Pisco. So we went through a bunch of stuff.
The black codes can't be used because they dealt to discriminate against a small.
No, I understand why you're saying they can't be used, but it's because we've moved away from that history, not because that history didn't exist. And so to the extent that...
Yes, but you have to acknowledge that history was bad. Ketanji. You have to acknowledge it's bad. Like, come on. Why did we move away from it, honey? Why did we move away from it? It's where that meme where the goose, like, why did we move away from it? Why do we move away from it?
The test today is tying us to historical circumstances. It would seem to me that all of history should be on the table. And if we start taking pieces off, whether it's because we've moved away from it or we don't agree with it anymore, I think there's going to be a problem with respect to the accuracy of our test.
Your Honor,
Let's try that with every other. Let's try that
Yeah,
with
really.
every other right.
Exactly. Yeah, let's look at all the times that Congress or any other person passed a law to restrict the First Amendment. Right?
Let's talk about all the times they restricted black people from doing anything. We got to take into consideration. I'm not. You're the one making the rules.
Stupid is real.
Yeah, she just. It's because it's guns, and oh my god, and like.
it's not just because we don't agree with it anymore. It's that the 1865 law is not relevantly similar because it dealt with a very small segment of society.
I think this is where, if you're him, you would say, we don't do it anymore because it's wrong.
Now
And it's unjust.
we don't do it anymore because we decided that black people counted as 5/5.
Yes.
You think that's too much for the Supreme Court?
Marlene says, Gorsuch just stirring shit up. Probably a little bit. Yeah, that's the thing here. Like, but yeah, I would have said we don't do it because it's unjust.
Those being discriminated against, whereas here, law is a law of general applicability. So the two
people other than the people in this small segment that you're talking about, who were a part of society, but I guess you're saying that for the purpose of this test, we're not going to consider what happened to them.
No, what I'm saying is that the black codes dealt with it wasn't a law of general applicability. It was designed to discriminate against, it was a racist law designed to discriminate against African Americans. Whereas here, the law at issue here is a law that...
That's how you do it. You'd say it was completely racist, you fucking asshole.
Racist and an abomination to everything that we believe in as Americans.
Mm-hmm. Yes.
Applies to everyone. We can't use a racist discriminatory law to justify a modern day law that applies to the general public, Your Honor.
Thank you.
Thank you, counsel.
Thank you.
Thank you, Chief Justice.
Fuck. She's like, I'll take my L.
It just don't make no sense.
Apparently it don't make any sense to her. And yes, chat, that is AI. That's not real. It's not real.
Ms. Harris?
Mr. Chief Justice, and may it please the court. Bruin held that states can't refuse.
And remember, chat, the United States government, we talk about it every time. They've got that special rule where they get to say, hey, we would like to talk. And the Supreme Court goes, cool. You get to. Nobody else has that right, but they do. And here they go. I think that's so, it's why doesn't everybody else get that right? Just, it's not fair to the rest of us. So here we go.
To license public carry. Hawaii can't gut Bruin by presumptively banning everyone licensed to carry from doing so at retail establishments or other private property open to the public absent the owner's express consent. That novel law offends our history and tradition. First, pretextual restrictions are by definition unconstitutional in why they regulate. Here, the law's text belies Hawaii's claim to protect property rights. Hawaii subjects just one right, the Second Amendment, and one class of people, the people Hawaii had a license to carry after Bruin, to its presumptive ban. Hawaii lets everyone else, including target shooters and hunters, bring firearms, machetes, and other things absent the owner's objection. Second, pretext aside, Hawaii can show no tradition behind its law. Its best analog is an unconstitutional black code. That's because from the founding, the tradition has been that opening property to the public authorizes carrying. I welcome the court's questions.
What's your best support for what appears to be your argument that a pretextual regulation is per se unconstitutional?
I would start historically with Blackstone and the meaning of the word infringed in the text of the Second Amendment. If you look to Blackstone, which is one of the main sources underpinning what the pre-existing Second Amendment right meant, the canonical example of a law that burdened impermissibly the right to bear arms was the English game laws, which under the pretext of trying to preserve game were designed to prevent commoners from hunting. And we know that was one of the animating premises of the Second Amendment from people like St. George Tucker, from Justice Story. And again, the very meaning of the word infringed in the Second Amendment shows this is part of the history and tradition underlining.
The analysis that you're suggesting, Ms. Harris, is this part of the Bruin test or is it something separate from the Bruin test?
It is part and parcel of the Bruin test. It goes to why the law is regulating the way it does in Bruin's words, or in the word of Rahimi, it goes to whether there's a permissible reason. It helps you tell whether the analog is really
you're on step 2 of the Bruin test. You think about pretext. Is that what you're saying?
I think that's fair because step 1 is, are you regulating arms bearing conduct? And so one of the parts of whether you tell, is this part of the history and tradition, and are the potential analogs really analogs, as you say, why is this modern law regulating the way it is? And if it's pretextual, by definition, you're not going to have analogs because there is not a history and tradition of pretextual laws that negate the right.
Why do we need to make it? Oh, go ahead.
Mostly in our constitutional law. I mean, there are exceptions here and there, but mostly in our constitutional law, we've steered clear from trying to evaluate motive, purpose directly. You know, we create rules that maybe are meant to ferret out bad motive, but we kind of think it's a bad road to go down if we're going to ask about every state's, whether the state is acting contextually in doing one thing or another. And I'm just wondering why we would have a different thought with respect to this right.
Because respectfully, that's not our position. We're not saying, think about what's on people's minds. If you have bad motives, it's bad law. What we're saying is look at the text and see if there is a fundamental mismatch. If the law is gerrymandered textually, which is the case here, in such a way that belies the assertive motive.
So that seems fair, but then it seems as though that's classic means end scrutiny. You know, look at over-inclusion, look at under-inclusion. Is the state really regulating what its interests would suggest ought to be regulated? So that's means end scrutiny, which I thought Bruin was supposed to get us away from.
So 2 points on this. Respectfully, no, we don't think so. We think Justice Churchill Willoughby and the First Amendment.
You're right over there?
No, that really fucking hurt my head. They are just being so fucking intentionally obtuse right now.
Context is a case about pretext and not sort of means ends. It's about how do you tell from the text of the law? Is it gerrymandered in an impermissible way? That's what we're asking for here. And the Second Amendment of all places in terms of history and tradition is where this test would apply. Because again, the original meaning of the word infringed in 1791, and they would point you to the Daniel Slade article on this, infringed, what included the Blackstonian concept that if you are regulating for a pretextual purpose that is belied by the design of the law, that is a classic means of infringement.
Why are we... Sorry.
Okay.
Why are we making it complicated? The text of the Second Amendment covers arms. Part 3 of Heller says that means what it's, Heller says it means what it says what it means. Part 3 of Heller says there's certain exceptions to that or contours on that which are rooted, but they have to be rooted in history. Here, there's no sufficient history supporting the regulation, end of case. Isn't that kind of the straightforward way rather than getting into this whole new elaborate pretext analysis, which, as Justice Kagan says, sounds like what we moved away from?
So absolutely, the case could rise and fall on the lack of history and tradition. I think the one...
It's pretty simple, right? Your position is there are no sufficient analogs. Usually when, as Heller says in Part 3, when you're looking for a historical tradition that justifies an exception to the textually expressed right, it's got to be a deeply rooted tradition, broadly consistent over time and broad among a lot of states. You don't have anything like that here. So it's just kind of, from your perspective,
Thank you for giving us the answer.
Pretty simple.
Yeah.
From our perspective, it's an overdetermined case.
Brett.
I think the reason you might want to go on...
Why not just, why didn't you lead with that? I don't understand why you led with the other argument, and it maybe neither here nor there at the end of the day, but I was trying to figure out why.
I think 2 reasons. One is because it would be a shame, I think, if the Bruin inquiry discounts the idea that, or just doesn't account for pretextual laws, given how rooted, how antithetical they are to the history.
What do you mean by pretext? Because a government often will look at one of our precedents and say, well, we don't agree with that precedent, but we want to regulate right up to the line of that precedent. There might be some gray area there. I mean, we don't call that pretext every time when a state government does that in the First Amendment.
No, and I understand. I don't want to fight this too hard because I think we are in agreement that this is an easy case at the end of the day. And every single way you look at it, there's no history and tradition.
Ms. Harris, on that, moving to that, there's been some suggestion that this is just, redefining property rights and has nothing to do with the Second Amendment. Of course, we don't allow governments to redefine property rights in other contexts that would infringe other constitutional rights. I'm thinking here of the Takings Clause in Tyler versus Hennepin County. But I'd like you to respond to that argument.
That is exactly correct. In no other context could you say that there's an exemption to constitutional restrictions just because you're trying to redefine the laws of trespass. The state cannot, and the First Amendment's another example beyond the Takings Clause. I think Lamont, for instance, is on all fours. You could have very easily said in that case, no big deal. Federal statute is just flipping the presumption. Normally, the default rule is recipients of mail get the mail unless they say no. Just flipping the presumption. Now you don't get your mail if it's on a certain topic unless you affirmatively consent and send in a very easy to send postcard. The court absolutely rejected that reasoning.
But Ms. Harris, can we just be
Very, very nice. Appreciate that. Very good.
Yes. Yes. It's insane that we would do this in any other situation. We would never do this in any other situation. And yes, Johnny goes, Johnny Osprey says, I like beer. Me too, Brett. Me too. But yes, these are good answers. It almost sounds like Anna Kasparian's up there arguing against the Supreme Court.
If Anna Kasparian wants to make these kind of arguments in favor of the Second Amendment.
Well, yeah, that's the weird part. But it sounds like Anna Kasparian to me. So I'm like, whoa.
specific about the Second Amendment right that you say is being infringed here? This is the point that I guess I'm still stuck on, is whether or not in a world in which we all concede, and I think the United States is on board with this, that the Second Amendment yields to the property interests of a private property owner, such that the private property owner gets to consent as to whether or not you can carry a gun on his property. When we're in that world, what Second Amendment right is being infringed when the property owner says no, or when the state says the property owner's consent has to be expressed?
So let me unpack that both in terms of the methodology and the ultimate answer. I think when you collapse the whole inquiry into a specific question of what happens vis-a-vis property rights, you're backing away from the Bruin framework. The two steps are,
I am backing away because the Bruin framework only applies where the Second Amendment is implicated. And
wow, that was kind of, that's a unique, that usually doesn't happen. Where they all start just, they usually are pretty good about not doing that.
Yeah, there's a little catty at the Supreme Court today. Damn.
Yeah. Yeah, here we go. So here we go. Let's rewind that again, chat.
The point that I guess I'm still stuck on is whether or not...
They still stuck, chat.
It just don't make no sense.
It just don't, apparently.
In a world in which we all concede, and I think the United States is on board with this, that the Second Amendment yields to the property interests of a private property owner, such that the private property owner gets to consent as to whether or not you can carry a gun on his property. When we're in that world, what Second Amendment right is being infringed when the property owner says no, or when the state says the property owner's consent has to be expressed?
So let me unpack that both in terms of the methodology and the ultimate answer. I think when you collapse the whole inquiry into a specific question of what happens vis-a-vis property rights, you're backing away from the Bruin framework. The two steps are,
I am backing away because the Bruin framework only applies where the Second Amendment is implicated. And what I'm suggesting is that the Second Amendment right is not being implicated when the regulation is about the property owner's consent, the form of it. Can it be implicit or must it be express? In a world in which we've said that consent already takes precedent over the Second Amendment right.
So what we're answering here is what is the scope of the right to publicly carry under the Second Amendment? And I don't think states can get out of constitutional scrutiny by trivializing what they're doing.
But haven't you already agreed that the Second Amendment right yields to the property owner's consent?
Of course, we're not saying that you override what property owners are saying, but what we're saying is when a restriction parts ways, when it redefines the concept of trespass to essentially say for this one category of people licensed to carry, you are no longer presumptively allowed to carry at gas stations.
But you're only presumptively allowed because the presumption goes to the consent, not to your right.
I understand.
You're presumptively allowed because we're presuming that in this situation, the owner is consenting.
And this goes back to the colloquy with Justice Gorsuch, which is when states are trying to redefine property concepts, that doesn't take them out of constitutional scrutiny. Quite the contrary, in both a First Amendment context and the Takings Clause context, the rule is when the states are departing from the default in a way that implicates other constitutional rights, they can't do that. The Takings Clause may be an outer limit in sort of what exactly states can do. But it would be, I mean, just the floodgates would open if the position were all that's going on here is just tweaking how you consent. Just think about, I think in the First Amendment context, you would say, no big deal. You are now going from a world where candidates can go door to door and for campaign speech, but now you have to have a big sign in your yard that says political speech welcome for someone to go in. Or in the Second Amendment context,
nice.
Hawaii's same reasoning would lead to
It's pretty good, right? Because
Yes.
could we flip it so that no one can go talk to people about politics unless there's explicit consent? Yeah.
Mm-hmm. She's gonna be like, I don't understand. I don't understand. That's what she's gonna say here. That's what she's gonna say.
a rule that it's fine to ban tenants from owning guns in self-defense unless the landlord in the contract expressly consents to doing so. And I really think the concept that this is just tweaking consent elides the burden that Hawaii is imposing here of presumptively banning open carry, banning public carry.
Thank you. Justice Thomas, any further? Justice Alito?
Would you explain why the anti-poaching laws that Justice Kagan was talking about are not, in your view, an appropriate analog?
Absolutely. Those poaching laws, as the Sigmund article and other sources and the text of the laws themselves exemplify, show the opposite of the tradition Hawaii is trying to show. They show that for property closed to the public, the people have taken steps to enclose for improvements to protect the fields from being trampled by hunters. For that special category, there were laws that said you have to get affirmative consent, sort of like Justice Barrett's questions about do you need affirmative consent to go into dwellings. The rule for other property open to the public, open fields, was the exact opposite. There's a conscious decision at the founding, because hunting was an incredibly important issue, that if you did not enclose your lands, it was an open invitation to carry, and that's consistent with the tradition at the founding of public carry that the NRA amicus, for instance, details. The idea that Hawaii's law is a relevant analog would just take the level of generality to just justify the opposite of the tradition. It would have been profoundly disturbing to the founding generation to hear that in order to travel at inns or taverns or anywhere else, people commonly carried arms, that they had to get the affirmative consent of each sort of tavern and hope that they weren't trespassing if they were traveling and their carriage had to stop somewhere.
In order to determine whether an analog is adequate for Bruin purposes, is it possible to disregard that? How do you choose the level of generality? What is the principle that tells you what is the relevant level of generality?
I think here the relevant level of generality does revert to some the property law concepts. If you're talking about property open to the public, the relevant comparator is property open to the public, because there is a relevant common law tradition of certain permissions to go there. And when the state is essentially presumptively banning or switching the tradition, I think that is an issue. So I think that's relevant. And to disregard the clear text of these statutes, which are focused both on property, that distinction between property closed to the public and open to the public, and the specific question of hunting, would allow you to abstract out everything. It's the same thing the court rejected in Bruin, that just because some places, for instance, might be sensitive places, every place could be a sensitive place on the same reasoning at too high of a level of generality.
What do you think is the purpose of the Second Amendment right?
The purpose of the Second Amendment right is to allow citizens to bear arms for self-defense and other lawful purposes.
And other lawful purposes?
Yes.
Not just self-defense. Did Heller say that?
I don't think Heller.
I love how Alito just squeezed that in there. Remember, it's not just self-defense. Just making sure, reinforcing things as we go here.
You think we can get the U.S. government to say it's for overthrowing us when we go to hell? That'd be good. Sarah, say it.
Yes, it's for hunting. Government officials.
It's for putting my head on a pike when we go too far. Say that, Sarah.
Well, yes, but that's the thing. The Second Amendment is about hunting. Tax collectors.
You're doing great, Sarah. Keep it up.
Yes.
And I don't think the court has to decide, is it self-defense and other things, but it would be, again, sort of strange to think that you cannot use arms for any other purposes when the founding generation considered arms important, not just for self-defense, but for instance, for making sure that people were proficient in arms to be able to defend the country. So I don't think that there is sort of necessary, but I don't think the case presents the question.
Do you think it's possible to ignore the purpose of the Second Amendment in determining the level of generality that's appropriate?
I think that it depends on the case. For this particular case, I don't think the court has to resolve it because the point here is Hawaii is saying its law is supposed to protect private property rights, and it's essentially trying to negate people's right to publicly carry everywhere.
Justice Sotomayor?
There's been a number of church shootings recently. Does the state or the federal government, does it bar from saying you can't go into a church without a gun, without the owner's permission, the church's permission? Is that illegal?
The answer to that question would go into the sensitive places inquiry, which is different from this case because that is sort of place specific. So the question would be, is there a history and tradition of allowing restrictions on people carrying in churches?
I suspect there isn't. So I suspect, I could be wrong, I never read about that. But if we're not looking at property rights and a government's right to regulate a presumption, then what would give the government the right to think that flipping the presumption in that case
They wouldn't.
is reasonable?
Sonia?
Again, I
Just
think
as
it goes,
here,
correct.
where most property owners for 200 years didn't carry weapons in this state without an owner's consent. That's the presumption of the Hawaiian people.
So 2 points on that. One, with respect to the presumption of the Hawaiian people. As petitioner notes, there is no Second Amendment for every single state in the union.
Thank
That's
God,
different.
say that.
It is a national tradition, and states cannot retain their pre-statehood traditions as sort of a veto
Preach,
for
Sarah.
the Second Amendment national traditions. So you look,
It's not a veto. No one's vetoing.
Yes, it is. You are vetoing it. Hawaii's saying you can do whatever the hell you want everywhere else, but here we're different. It is a veto. It is a veto. Well, it's a right, but we're not allowing you to do it.
Yeah.
Okay, so it is a veto. Well, no, it's a veto. We're just telling you no, which is what a veto is.
Yeah.
Vetoing an owner's right explicitly or expressly to consent to carrying guns. The owner's the one with the right.
so to be clear, what I mean by that is you can't use local customs to say that each state gets its own Second Amendment. The court has rejected that very type of analysis in the takings clause, for instance, in Hennepin County, in Cedar Point, where the court said, even if California has a kind of unusual way of defining.
Hey, Chad, I don't know where the captions went. Huh.
Sean fucked up.
Yeah, I know I did. Hold on here. We're going to refresh this. No, guys, Cedar Point, I think they were talking about California,
Explicitly
not
or
like Cedar Point,
expressly to
Ohio,
consent.
I believe, if I know the case right. I don't think
Is highly unusual.
There's
as
not
the
a case
Ayers
about
article
Cedar
itself
Point.
acknowledges, in all 50 states and the District of Columbia up until Bruin,
Okay, so where the hell are you? Subtitles, English. Let's see if auto generate. Okay, there we go. I don't know what the hell happened there. Let's keep going.
the universal rule, and this does trace to the founding, is that when you have property open to the public, you are inviting people to go on it with arms unless the owner says otherwise. We think that implicates the Constitution, the Second Amendment, for the same reasons it implicates other amendments and other
Presumption
contexts.
doesn't change that. The presumption lets the owner choose.
The presumption is that you're trespassing. It treats just for one class of people. It turns essentially property open to the public, like a gas station, into the equivalent of someone's house, where you're committing a crime under Hawaii law if you actually go onto it without consent.
Mrs. Kagan?
Can you imagine, Ms. Harris, any modern analogs of these anti-poaching laws? I mean, I guess what I'm asking you to do is to say, are there any modern laws that sort of use this kind of authority over, consent and licensing and so forth, but that don't have to do with hunting, that would be permissible because they're very much like these anti-poaching laws?
So two answers. One is obviously these laws themselves have endured throughout, which is why I think maintaining the distinction is important. But two, you could say it's not that distant, but there is a separate tradition with respect to property close to the public, like your house. What are the relevant permissions? What's the default for property close to the public, setting aside hunting? And I think that's consistent with the way these laws work. I mean, Justice Sotomayor mentioned the 1763 New York law, and that's talking about enclosed property like orchards or gardens or other stuff, and saying if you carry arms on that land, that's a trespass. But it's also saying you can't trespass generally in these places. So I think it's getting to the idea of if you have particular property that's close to the public, you might not want people with arms on it. That is what these sort of founding era laws say. You don't want them trampling your cornfield and destroying your improvements because it's closed to the public. Similarly to, you might be able to say, and again, this is a matter of like what the history would actually show. So
if I can, your objection to the use of these old laws really is just that the Hawaii law applies to all, although it's private property, it applies to property that is entirely open to the public for all other purposes and with respect to all other activities. And that's your view of why Hawaii is different. And if the Hawaii law was narrower than that, or if some other states were, then you would have a different question.
I think it would present different questions. And yes, that is our main objection. And the reason is Hawaii is trying to use laws that actually show the opposite tradition, which is laws closed to the public. You might need affirmative consent in order to be able to hunt on them. Property open to the public, though, is the exact opposite rule from the founding on otherwise, in order to ensure that people could publicly carry absent objection. And so, yes, I think that that is the most critical point about these laws. The fact that they concern hunting, I think, is a relevant additional factor that goes into what was the point of the presumptions. But the fact that it's hunting and also sort of other forms of trespass, I think, is the bottom line.
Thank you.
Justice Gorsuch?
There's been the suggestion that this is just flipping a presumption about the implied license and that that's just a matter of property law and not the Second Amendment. But how do we think about that, given that it flips the presumption on the longstanding implied license only with respect to firearms, and not knives, not solicitation, not politicking, not anything else?
That's exactly right. I think there's two ways to think about it. One is we do think that that makes it much more like the kind of pretextual laws that founding generation thought were anathema to the Second Amendment, because you're singling out a particular right in a particular group who's committing trespass when everyone else isn't. But two, just going back to this concept, you can't just say, you're tweaking how to give consent and you're out of the Constitution. When a state is saying you're presumptively banned, you're committing a crime unless you get consent, that is a much bigger deal than just sort of tweaking the edges of property law. And in no other context has the court said, no big deal, the Constitution doesn't apply, this doesn't even implicate the relevant constitutional inquiry.
What are the implications? Hawaii allows oral consent to be sufficient. California had a law requiring a posted sign. The Ninth Circuit struck that down while allowing Hawaii's law, but I'm not sure I understand the distinction between the two. Why couldn't a state require affirmative signs? Why couldn't it perhaps create an irrebuttable presumption against consent?
I think that is exactly where Hawaii's position leads. I don't think there's any principal distinction between those two things. And again, it's not just sort of, is it easy to get one person's consent? How hard is it? That's kind of interest balancing at the outset. But as a practical matter, in order to run your errands, you have to run the table of knowing you're not trespassing on private property to like pick up your dry cleaning and catch a cup of coffee. And if you run out of gas and you're trying to find a gas station, you can't get gas unless you're in your car, you have your gun in your purse, and you're not actually committing a crime by stepping on the gas station property. Now, Hawaii is trying to say it's a little easier than that, but the text of its law says just entering the property without permission is a crime.
And then lastly, there's been some discussion about the black codes, and maybe they should be relevant, and maybe we really should consider them as significant here. In fact, they're a dead ringer. Thoughts?
It is 2026, and it is somewhat astonishing
it's current year. I don't know if I'd answer that way.
Are being offered.
I don't know if I'd answer it's current year. That's a little, I don't know about that.
That's a very Reddit answer, but know, it still kind of works.
Yeah.
It still kind of works. Yeah. But it's like, yes, we're dealing with this.
as evidence of what our tradition of constitutionally permissible firearm regulation looks like. Those laws are dead ringers only in the sense that this law too is an unconstitutional pretext. The black codes were offered, as you mentioned, by states before their readmission to the Union. It is not an indictment of the Bruin framework to say that unconstitutional laws do not count in illuminating a valid tradition. As Bruin and Rahimi themselves say, you're looking for laws that aren't outliers. They illustrate what the national tradition entails. And so it is no indictment, but frankly, an endorsement of our history and tradition that when you look at the founding era laws, they are very different from the black codes, and that these black codes themselves are complete departures from what the laws in Louisiana and other states were like before, which was to allow people to presumptively go about in public on property open to the public without consent.
Thank you.
Justice Kavanaugh?
For purposes of the textual and historical tradition analysis specified by Heller and elaborated upon by Bruin, Heller's Part 3 on exceptions remains very important, I think, in my view, at least. Do you agree with Part 3 of Heller, accept Part 3 of Heller?
Yes, we are not trying to depart from anything that this court has said with respect to its Second Amendment precedents.
And then in Part 3 of Heller, the court said that nothing, in our opinion, should be taken to cast doubt on laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. Do you agree with that?
We agree with that, and I think as elaborated by Bruin, I think the question is, how do you define relevant sensitive places at the correct level of generality so that not every place is a sensitive place and so that you are looking to the right historical analogs?
Understood, but you agree with the principle as stated there?
We agree with the principle as stated that there are obviously sensitive places. You determine them with respect to the history of firearm regulation.
Thank you.
Justice Barrett?
Mr. Harris, I'd like to talk about the relevant analog in these anti-poaching laws. And one question that I have is along the same lines as Justice Kagan, which is when you're thinking about these anti-poaching laws, you're thinking about a problem that arose at the time. So at the time, poaching was a problem, and so legislatures enacted this regulation to address the problem. In an agrarian area, an agrarian society, that was it. Let's imagine that Hawaii, rather than just flipping this default categorically, instead is experiencing, say, a rash of gas station robberies. And doesn't want to make the argument that gas stations are sensitive places. That would be a tough one. So instead flips the presumption like the anti-poaching laws, just with respect to gas stations.
How is that going to help with the
okay?
robberies?
Not okay, and it's still
Just out of raw curiosity.
I don't know.
You know what we have? We have a lot of gas station robbers with firearms. I know what we'll do. We'll make it so that unless you request permission to bring a firearm, you can't. And that way the robberies will stop with the firearms.
Yes. No, I think that's, it's brilliant thought. How this is going to work out. Yeah, it's same way, like, for school shootings, just say, don't bring guns to school. It's against the law.
runs up in the basic distinction that we're seeing, which
is, while we're at it, Kurt, we can just pass a law saying you're not allowed to kill people. Fix the murder problem right now.
When the history and tradition is for the type of property open to the public, to have an implied license to go into the property, when the state is trying to load the dice, when it's trying to say you generally can't go there, it has to point to relevantly similar analogs that are doing the same for the how and why. And the anti-poaching laws, it's not just that they're about hunting, it's about that they're the specific part of land. It's almost like they're the exception to the general rule that on property open to the public, you can generally carry, on property closed to the public,
how do you know that's the relevant distinction? I mean, it could just be that, well, that is an incidental of the problem. I mean, that just happens to be where the problem of poaching arose, which was on enclosed lands, because those are the people who were trying to protect themselves from poachers. But I mean, there might have been poaching on open lands too. And then the legislature might have responded differently. I think this is this problem of just because the legislature didn't address a problem because it didn't exist at the time, why does that mean that the analog ties the legislature's hands now?
And I think the answer is that is under, you look to the broader articles and I think history of what was going on with the anti-poaching laws. It's not that, poaching on or hunting on open lands open to the public wasn't a problem. It was actually at the founding, it was a hugely politically salient and highly debated issue, so important it was in state constitutions, that this was a sort of elemental distinction to the founding generation that's carried on our property law, that property open to the public is not, you're not trespassing. if you're hunting on that land. And property closed to the public, you want to protect the improvements, and so you are allowed to restrict it by changing the rules so that you have to affirmatively consent. And I think you know that from the laws themselves, actually. I think the laws themselves make that distinction. I would point you to the New York 1763 law. The 1771 New Jersey law is of a piece with that, and the Sigmund article is sort of canvases the history, but like I think this is not just, well, it's sort of strange they were focused on this particular type of land. What do you draw from it? They were extremely focused on this because it was a huge political topic.
But Ms. Harris, then that raises this question for me. In footnote 1 of your brief, you say this case does not concern property closed to the public. So the court need not address state laws that prohibit carrying a firearm into a private residence without the owner's affirmative consent. But both you and Mr. Beck are drawing this distinction in the anti-poaching laws between property that is open to the public and property that is closed to the public. So I guess I don't understand how, if you win this case and we do the history and tradition analysis and you win, how is the court supposed to distinguish that analog in the way that you're proposing we do without deciding this question you tell us we shouldn't be deciding?
Right. So I think two things are important. One is when you're deciding whether the analogs are on all fours, it's inescapable, and it runs throughout the position that there are different permissions, different common law traditions applicable to property open to the public and property closed to the public. I don't think that is a complete answer, and the reason we're saying it's just not presented is it's not the question presented to whether property closed to the public, what the range of permissions is. For instance, if I invite someone to my house, what is the tradition with respect to that?
So maybe the state could flip the presumption in the way Hawaii has done here, but just with respect to private residences. Mr. Beck said no to that.
We're leaving that open because we're thinking of this as, again, different property traditions. And so they would have to show a relevant history and tradition. Again, I think that would be likely easier for them because the rules regarding property closed to the public have always been different than property open to the public.
Okay, last question. On your broader argument, you state the rule pretty broadly. I'm looking at page 11 of your brief. You say a law is per se unconstitutional if it broadly prevents ordinary Americans from carrying protected firearms in public. Who is an ordinary American, and why? Kind of throughout your brief, you use that formulation, but as I recall in Heller, it says ordinary law-abiding Americans. Why not the law-abiding, and what is an ordinary American?
I don't think we're trying to suggest any difference between ourselves and Heller and our position here. I think we're frankly using it as a shorthand.
Okay, thanks.
Justice Jackson?
So I guess I really don't understand your response to Justice Gorsuch on the black codes. I mean, I thought the black codes were being offered.
She just doesn't understand, chat. Wait, why can't we use the codes that would discriminate against me and prevent me from doing any of this? I thought those were okay. Like, seriously. I don't understand. They would completely disenfranchise me. Why can't we use them anymore?
Yeah.
It just don't make no sense.
Here under the Bruin test to determine the constitutionality of this regulation. And it's because we have a test that asks us to look at the history and tradition. The fact that the black codes were at some later point determined themselves to be unconstitutional doesn't seem to me to be relevant to the assessment that Bruin is asking us to make. So can you say more about that?
Absolutely. Black codes were unconstitutional from the moment of their inception because they are pretextual laws that are designed to ensure that newly freed slaves are returned to a condition of sharecropping.
Okay, let me stop you there. They were not deemed unconstitutional at the time that they were enacted.
That's not what she
said.
said.
Of the history and tradition
That's
of the
not
country.
what she said.
And when we have a test now that's asking us to
didn't
look
say
at what
deemed,
people
they
were
said they
doing
were.
back then, I don't understand why they should be excluded.
Because they are outliers. They are by definition unconstitutional. They have
Found
been
later,
unconstitutional.
afterwards, not at the time. And if the test says what's happening at the time tells us what's
Is she arguing
constitutional
in
for
favor
this
of black
purpose,
codes now?
why aren't they in?
Respectfully, a law is always unconstitutional. When it's from its inception,
So the history doesn't matter. We shouldn't care about the history then.
We should deeply care about the history, but the whole point of the Bruin framework is as follows. The history and tradition of the Second Amendment are particularly important because it is codifying a pre-existing right. To figure out in sort of common law fashion what the national history and tradition are, you throw out outliers. And I can think of no greater outlier than blatantly unconstitutional laws that flipped what had been the tradition in states like Louisiana. And during the period before those states were readmitted to the Union, for the purpose of trying to reduce newly freed slaves back to conditions of servitude, made it a new crime, new trespass, in order to go about armed on private property. Those are obvious outliers.
All right,
It should not count under the whole point of Bruin.
Mr. Katyal will address it. I just have one more question. I'm trying to understand whether there is a Second Amendment problem in the following circumstance. So what if a state that's trying and hoping to dissuade gun rights, so it fits your view of like a state acting in a pretextual way, passes a law providing for free no gun signs to every business? And they're really very invested in this, so much so that their law offers to send these signs to every business, offers to send someone out to put the signs up at the business owner's request. Do we have a Second Amendment problem in that situation?
If you're just, no, I don't think so. You're not having a law that's regulating arms bearing conduct. I think the premise of the hypothetical is you retain
But
the
it
existing rule.
affects arms bearing conduct, perhaps in even a more egregious way than what you're talking about here today.
I think we go back to the words of Bruin and Rahimi.
And their purpose is to dissuade. That was part of the hypothetical. So your test was about the purpose of the state. We have the purpose here. We have the effect here. 97% of the businesses, let's say, in Hawaii, under the test that the law that I'm positing, accepts this offer.
Yes, and what I'm trying to distinguish is I think your hypothetical really illustrates what we're not doing, which is a bad legislative motives purpose and sort of effects test. Whereas what we're saying is our pretext argument is very firmly rooted in the idea.
Right, I just want to know, is the Second Amendment implicated? And I think you're saying no, and I don't understand why it wouldn't be in this situation if it is in the situation here.
Because in the law that Hawaii is enacting, it is regulating arms bearing conduct by saying, if I carry my gun to a gas station, I am presumptively committing a crime. That is a direct regulation of where and how you can bear arms, under what circumstances. You are hypothesizing a situation in which the state is merely subsidizing certain types of speech. That might have other constitutional problems, but the problem is not going to be with respect to regulating arms bearing conduct in the way that we think Bruin is talking about.
Thank you, counsel. Mr. Katyal.
Thank you, Mr. Chief Justice, and may it please the court. This case is about two fundamental.
Now, chat, this guy, Neil Katyal, he's a heavy hitter in the Supreme Court lore and the Supreme Court universe. He's also the guy famously went out to Burning Man, looked like a fucking douchebag like a year or two ago when it got. You didn't know that, Kurt?
I missed that one.
Oh, there was like a whole thing of him going out to Burning Man. Everybody's like, you look like a fucking tool. And he got stuck out there when it rained out and they all got stuck in the desert.
In what particular way did he look like a tool?
I mean, he just dressed like a complete fucking toolbox.
All right.
He was dressed up like, hello, fellow youngsters.
Anyways,
Anyway,
he's just trying to broaden his horizons.
Yeah.
I appreciate that.
Yeah, but anyway, his job, guys, he's a hired gun. He's got the experience. He's got a name. All that stuff, you're going to use that stuff to get an advantage of the Supreme Court. So he doesn't work for Hawaii. Hawaii hired him for this sole purpose. He's like Paul Clement. He's used as a mercenary solely just to go argue in front of the Supreme Court. Also, real quick, yes, Tex.
They didn't trust their own Solicitor General to do the job.
Yeah, well, I mean, it says a lot there. Their own Solicitor General didn't want to go argue in front of the Supreme Court. No, I don't want that honor. But yes, apparently that's the case. Yes, Tejas Libre says Hawaii already has a trigger law if they lose. It says all businesses must post color-coded signs on their doors if it's allowed red or prohibited green. That's really fucking confusing.
Yeah,
that's really confusing.
That's backwards.
Yeah.
That doesn't make sense.
What happens if you're colorblind?
That too.
Oh no, it's discriminatory, chat. We're gonna get the ADA involved. Holy shit.
What shade of red and green?
Yeah.
rights, the right to bear arms and the property right to exclude. And there's lots of agreement among the parties about how those rights interact. Everyone agrees there's the right to carry on private property if the owner wants guns on his property. That was elicited by Justice Sotomayor to my friends. And everyone also agrees there's also no such right if the owner doesn't want guns. The only question is whether there's a Second Amendment right to assume the owner wants guns on his property when he's been silent. There is not. There is no constitutional right to assume that every invitation to enter private property includes an invitation to bring a gun. The Constitution protects the right to keep and bear arms. It doesn't create implied consent to bring those arms onto another's property. At bottom, that is petitioner's theory, and yet they have zero support for this. Zero support from the founding or for the next 200 years. No treatise, no commentator, no court. Not only is there zero affirmative support, it runs counter to our traditions of implied consent. From the founding and Federalist Paper 45 on, states have used law and custom to clarify the rules around consent. In some states, it's natural to say when a homeowner invites you in, they're fine with you bringing your gun unless they say otherwise. But in others, it's pretty obvious that if you bring your gun to someone's house, you have to ask. And the same is true for stores. In some places, it's reasonable to assume guns are welcome. In others, it's pretty clear an invitation to shop is not an invitation to bring your Glock. It's reasonable for a state to clarify these defaults, passing laws that say you can assume consent absent permission, or as here, that you can't assume it. The Constitution permits this type of democratic flexibility in states functioning as laboratories. Before rigidly constitutionalizing one type of property default rule, this court should insist on at least some evidence that the Second Amendment so requires it. I welcome the court's questions.
Are there any other constitutional rights that you could place on which you could place similar limitations?
Sure. I think the general proposition of the law is that property rights, are
open to the public. Always add that part. We're not talking about private homes. We're talking about restaurants. We're talking about malls, things like that.
Yeah, so I do think, first of all, I do think they are talking about private homes. That's what I think ultimately my friend conceded to Justice Barrett earlier in the
I thought he made the distinction between private homes versus private property open to the public as opposed to closed to the public.
Justice Thomas's brief made that distinction, but at least as I understood what he was saying at argument, that his rule would apply even there. And I think this is what's so dangerous about his rule, because he's saying, look, as long as something has to do with guns, then we go right to Bruin step 2 where the burden is shifted.
Well, that's, I'm not going to argue that point, but I do want to know if there are other constitutional rights in similar circumstances on which you could place similar limitations.
I do think that there are. I think here, this case concerns guns, but sometimes, like, for example, this court's decision in Breard recognized for some First Amendment restrictions, you could have a change in the default rule, and that was understood as constitutional. Here, we're just following the
So
long.
suppose there were a state that said, we're going to flip the default rule so that you cannot leaflet in shopping centers unless you secure permission first. Yeah. Would that be constitutionally problematic or not?
The problem there is that oftentimes in the First Amendment context, the First Amendment rules are different than the Second Amendment because they forbid content discrimination and viewpoint discrimination. And a leafletting law often will have some sort of illicit thumb on the scale for a certain set of viewpoints. And so that's
like any leafleting for anybody.
Yeah. So
on any subject.
Right. In that circumstance, this court's precedents on viewpoint and content are so broad, it might encompass that. But even if even if you could jump past that, you'd still have to at least have rational basis review. This court in Free Speech Coalition versus Paxton recently said, even for stuff that isn't encompassed in the First Amendment, you still have to have at least some rational basis. Your example would flunk that. Here, Hawaii's done the opposite. There have been no guns effectively in Hawaii for 200 years. The underlying, expectations and local custom, as Justice Sotomayor was saying, was that nobody had to think about guns. What the Hawaii legislature said here in the wake of this court's Bruin decision.
They didn't have to think about fucking electricity either. They didn't have to think about fucking penicillin. Or not throwing fucking, not throwing people into volcanoes. We did that.
They were too busy thinking about burying a pig and then thinking it back up later for some reason.
Yeah.
Yeah.
Yeah. Also,
spam.
Real quick, Texas Libre did point out that where did he put down here? I think he said yes. Yes, remember Hawaii is an archipelago, meaning a chain of islands, chat. Declared all beaches to be a sensitive place. And prohibited, well, see, that's good because when the Chinese invade, they're not going to be able to do an amphibious
There you go.
invasion.
Yeah, that's right.
They'll
No
have
guns.
to use paratroopers. It's like, you can't bring guns here, sir. Also, you can't, the volcano is a no-gun zone, too. So you can't shoot at the volcano.
If only Hawaii had thought to pass a law that made attacking Hawaii in World War II illegal.
Yeah.
Yeah, that'd be good.
That too.
It's too bad it wasn't illegal. Too bad it wasn't illegal to attack a U.S. military.
Yeah, too bad. Yes, too bad it wasn't illegal to fly low over the Hawaiian Islands.
Yeah.
Yes, was that those bombs weren't those torpedoes weren't registered. But no, so there's a no gun zone. So if you're at Kilauea or whatever it is, and the lava starts coming at you, you can't pull out your gun and shoot at it and defend yourself because you can't bring a gun. So, and yes, Jefferson Post is right for $2. Looks like slavery's back on the menu, boys. Oh, yes, and I agree. Hawaii should be disallowed for citing any law before 1959. Yeah, I mean, like, they were federal territory. Like, yeah. But yes, that also, Chad, if you weren't sure, Hawaii has not been settled for that long in terms of human history. It's not like many of the places where humans have been around for long, long times. It's actually fairly recently been settled. So.
Is Bruin's a real game changer. And as a result, some shop owners are going to be caught unaware. They're not going to realize that someone might have a concealed Glock on them and the like. And so to vindicate those expectations, they said, we are placing the default rule there on the property owner to say whether they wanted to affirmatively invite guns in. And in choosing where to place that responsibility and that burden, I think it's absolutely reasonable for the state to place it with private property owners whose consent is required.
Counsel, I just want to understand, because one of the motivating concerns, and you can see it in our decisions under the Second Amendment, is that it is a disfavored right. And it strikes me that one of the things that your side of the case has to come to grips with is that it is a very clear constitutional right under the First Amendment. If I, for example, as a candidate for office, want to walk up to your door on private property and knock on the door and say, here, give me your vote, that's exercising the First Amendment right. But you say that it's different when it comes to the Second Amendment, that you can walk up. So when the candidate wants to walk up and he's carrying a gun, what exactly is the basis for the distinction? Because part of, again, what our precedents talk about in this area is that the Second Amendment has been treated as a sort of, a second level right. And that's one area where given this law, I don't really see the basis for the distinction.
So we totally agree. The Second Amendment is no disfavored right. At the same time, there are rules about the Second Amendment.
Really, you sure?
Laid down in Bruin,
you sure about that?
Which you've said.
Where's that meme where the guy just says, "You sure about that? You sure? Really? You don't think the Second Amendment's disfavored right? Liar."
Yes.
The relevant question is whether or not the scope of the Second Amendment's text as informed by history would say that there is a violation of the right. With the First Amendment, you've got burden tests and all sorts of stuff that this court disclaimed in Bruin at page 22. And so it's just going to apply somewhat differently. But our fundamental point to you is, yes, this is a law that which traces back to the founding with other laws like New Jersey in 1721 and 1771, laws that basically said, look, when you're bringing guns onto property, even property open to the public, that states are free to flip the default rules. Indeed, that is what happened, going back all the way to those early examples. And my friend on the other side is, I think, selectively reading those to say, the Solicitor General saying, these laws are just about poaching and the like. Absolutely not. They have no answer to what we said in our red brief, which is that these laws dealt with improved lands, and improved lands were, as Professor Hertog says, stores, seed stores, and things like that.
Right. But let me just switch gears a little bit. We talked about the tradition in Hawaii. Hawaii, given its obvious origins and its admission to the United States fairly recently, has a totally different, in some areas, tradition and practice. The law of property in particular in Hawaii. I mean, for the longest time, maybe it's still the case, is that you don't own property, you get a long-term lease as if you were a bank in a skyscraper in New York. That was the common method. And I wonder.
It's true. I mean, technically, that's still the case. If you don't pay the government your rent, they take your land. So it's not really yours at the end of the day. Just saying.
There was also that pretty famous case with Hawaii in particular, where they basically eminent domained all the land.
Yes.
All the land.
Yes, all the land in Hawaii, yes, happened. Yes.
Yeah, that was the thing.
Mm-hmm.
Yep.
Mm-hmm. As was mentioned earlier, it is part of the United States. And do we have different traditions in different states when it comes to applying Bruin?
No, Your Honor. I think my friend on the other side has mischaracterized our argument. Our argument is that the Second Amendment means the exact same thing in every state. No Second Amendment right to enter private property.
That means no other state agrees with you that this is how you do it. So how does that work?
Without an owner's consent. What varies is what the definition of consent is from state to state, and local law and custom help inform that. That's what I think that Justice Holmes' opinion in McKee recognizes. So just to take a simple example.
Well, just before, I don't want to lose the thought. You said part of the history and tradition is there's no right to enter private property without the owner's consent, right? Mm-hmm. Well, we know that that's not a through line, right? Because you do have a right to enter the owner's private property if you want to exercise your First Amendment rights, right?
So not without their consent, Your Honor.
Sure. I don't have to have a sign on the sidewalk before you enter my property saying, okay to come on if you're going to give me some leaflet, or okay to come on if you're a candidate. The assumption is that there is a First Amendment right. Yes, you can withdraw it. And again, I'm just trying to figure out exactly what the difference is between the First Amendment and the Second Amendment.
What I think what's doing the work in your hypothetical about the leafleting or something is the government is putting its thumb on the scale of some sort of speech and saying they're worried about some type of leaflet or the like. To the extent that they just ban it entirely, it would flunk rational basis review. The relevant right there is not located in the property in the place it's spoken, but rather that the government is coming in and affirmatively taking a position.
Thank you, Counsel.
Well, Mr. Kyle, I don't understand why you're resisting the First Amendment. Well, I do understand why you're resisting it, but let's say there's no content discrimination. It's just a ban on leafleting, and it's a ban because people don't like solicitation. So they just don't want people passing out pamphlets. It's not aimed at Jehovah's Witnesses or anything like that, like some of our old cases. Why would that fail rational basis review?
So I think it might, because as this court said in Free Speech versus Paxson, you still have to have some underlying rationality.
Yeah, people
for it.
find it annoying. They don't like it. They think it affects their businesses, and people don't want to go to businesses if they're going to be accosted by pamphleteers.
But it may be a rational basis problem, but I don't think it's a First Amendment problem. This court in Rowan said that, quote, the right to engage in expressive activity generally stops at the outer boundary of every person's domain.
And that's the point.
Let me one more question. So let me take it out of the First Amendment for you. I mean, let's pretend that public accommodation laws don't exist, because the 14th Amendment doesn't apply to private action, only state action. Let's say that a state, in the absence of public accommodation laws, decides to flip the default and say, unless the owner affirmatively consents, Black people cannot enter your home.
Nice.
Yeah, so I think that's one which would be unconstitutional.
Why?
Every day of the week.
Nice. Love it.
Yes.
Thank you, Miss Barrett. I've been wanting for someone to ask this question. What if they put up a sign and say no Protestants allowed?
Yes.
And
now,
say,
in this hypothetical,
unless,
by the way, the
Yes.
Civil Rights Act doesn't exist because we're looking for a constitutional analysis, right? Or for that matter, we're flipping the Civil Rights law. Either way.
the owner.
So what if we said like no Blacks allowed, no Protestants allowed,
No Indians allowed?
How are you feeling now?
Yeah.
Is it working for you? Are you having some problems with that?
Yes.
Affirmatively consents, Black people cannot enter your home.
Yeah, so I think that's one.
You know, he has to say, well, that's different.
Which would be unconstitutional.
Why?
Every day of the week, because it would violate the Equal Protection Clause, because the government on its face is making a racial classification. So
Because there's state action in the way the government is adjusting its property defaults.
Absolutely.
Even if there's a long history and tradition, say in Louisiana, of this kind of discrimination.
You bring it, Miss Barrett. Oh, you sail it.
Yes. Hey, Louisiana, they did this. They didn't do it in Ohio, but it's okay. It's okay.
What if it was South Carolina? Long history and tradition, huh?
Yeah, South Kakalaki.
What if it's New Orleans? I have a painting about that on
what
my
if it's
wall.
Arkansas?
Nice. Bear it for the win today.
Yes.
Doorstep.
Right, it would still violate the equal protection.
Why isn't there state action here when the state is flipping the default? It's not just a matter of property law.
Right, our point is not that whether there's state action or not, it's that there's no underlying right. It's that my friend assumes, is conceded this. He said there is no right to come onto private property absent consent. And so the only question is whether the state can fill in the conditions.
Yeah, there's
of
no
that
right to
consent.
come onto private property without consent. So my public accommodations example is right. I mean, absent a public accommodations law or in a private residence, you could turn someone away on the basis of race.
But there is no anti-discrimination component in the Second Amendment the way there is with the equal protection
Okay,
clause.
what,
And so
what
that's
if a
why.
way
it's
to
not-
miss the point?
No, you're
That's
just
just
relegating.
great. What a way to miss the point.
Yes. Yes. Well, we wouldn't do that. Well, technically.
No,
we
it's just
could.
like this. It's just missing the point. Well, she's like, there's no anti-discrimination point in the Second Amendment. That's not the point of the question, Neil.
Mhm.
Thanks for missing the point, Neil.
Reform thoughts. Why can't she be this based all the time? Well, we got to take what we can get.
The Second Amendment to second-class status. I don't see how you can get away from that. If someone owns a store, or let's say it's a little restaurant, and this person has very strong political opinions and does not want anybody in that restaurant who is wearing attire that is expressing approval of a particular political candidate, that person, the owner of that restaurant, has the right to say, you can't come in, right?
Yes.
All right. Now, could Hawaii enact a statute that says that if you are wearing the attire expressing approval of a particular political candidate, you can't come in unless you get express consent from the owner of the restaurant?
Again, that's a viewpoint discrimination and prohibited.
It's a
by-
violation of the First Amendment. We have a violation of the First Amendment and a violation of the right that the court held is protected by the Second Amendment in Bruin, which is the right of law-abiding citizens to carry a firearm for purposes outside of the home for purposes of self-defense.
I quite agree with much of what you're saying. I think what's the difference is that the Second Amendment, it's not a second class right. It just doesn't have the same components of viewpoint discrimination or anti-discrimination for the 14th Amendment. That's just not in the Second Amendment. And I think the key point here is the court, if you accept my friend's invitation, you for the first time would be saying there is some sort of right here which no commentator has recognized, no treatise has recognized, no court has ever recognized. Compare this to Bruin, in which you had St. George Tucker, you had many state decisions in the 18th and 19th centuries that said laws like the New York one were unconstitutional.
Well, Justice Sotomayor cited a poll about what the people of Hawaii think about the possession of guns.
Mhm.
I'm not aware
Yeah.
of the poll, but let's assume it's correct. Let's assume that 78% or whatever the figure was in the poll that she cited really don't like guns. So what then is the big deal about this statute? Why does it matter if store owners and owners of private property that are generally open to the public don't
Very
like
good
guns?
point.
Why is it a big deal to say they want people carrying guns to stay out? Just put up a sign.
Yeah.
Why does Hawaii have to have this law?
So I think Hawaii has, like all state legislatures, has the right to put a default rule in that tracks the expectations of its people.
That's true. Then what's wrong with California's law, which flipped the default rule and said it can only be overcome with a sign?
Right. So I do think California's law would probably be constitutional, but our
The Ninth Circuit didn't think so.
Yeah.
The Ninth Circuit doesn't think so. You're in trouble.
Yeah. Mm-hmm. Mm-hmm. Oh yes, he is also basically defending Nestle when they were advocating slave labor. Yes. Yes, he is a lefty, and there are many in the left who hate him for many of the positions he's argued. And he's argued some pretty fucked up things in front of the Supreme Court. Yes.
argument doesn't depend on it
So
because
you
Hawaii.
disagree with the Ninth Circuit's decision on that score.
I do, but I
And
think
so
that here.
a result here, you'd admit would logically entail permitting California's law or ones like it to pass.
No, you don't have to go that far.
Oh,
You
I know I
can
don't
say-
have to go that far, but you just said you would go that far.
I personally would, but I don't think
Okay.
you do, Justice Gorsuch. So the reason.
No, I appreciate your candor about the extent of where your argument leads. And so it seems to me that, you could have a state law that doesn't just flip the presumption and require express oral consent, but requires express written consent, maybe a sign, maybe an irrebuttable presumption, flipping of it. I appreciate your candor on that. The other question I want to ask you is the black codes.
The black code.
I struggle to see what relevance laws that are outliers, and in Bruin, we're not supposed to consider outliers, that they're put aside under our test. We're looking for the mainstream and a significant tradition. And you rely very heavily on an 1865 black code law in Louisiana. You say it's a dead ringer and a reason alone to affirm the judgment. And I really want to understand how that could be.
So let me take those in turn. So first, with respect to the California law, I think it's really important to understand here the Hawaii law has a much broader definition of consent.
I know it does. That wasn't the question. Why don't you answer the question posed?
About the California law.
I want to understand how you think black codes should inform this court.
Yes, and this is the quote I saw from the transcript. I want you to understand, explain to me how we should use black codes in this is here. This is an awful question. Oh God. I would not want I would think it'd be fun to be in front of the Supreme Court. Holy shit, imagine having to answer this fucking question.
That wasn't the question. Why don't you answer the question posed?
About the California law?
No, I want to understand how you think black codes should inform this court's decision making. It's quite an astonishing claim to me.
So the black codes are.
He's trying to be very nice. Gorsuch is being very nice, but he's very incredulous, and you can hear it in his tone. Like, fucking run that by me one more time. Why you think I should use black codes right now? Run that by me one more time. This is, and this is a white man demanding this of an Indian man. It's like, explain to me why you want me to do this again. Well, yes, Your Honor, because my case would fall apart without it. Yes. Yes. Your Honor, I'm here to win at all costs, and if that means I have to enslave black folks again, so
I
be it.
swear, if Jackson's opinion actually cites the black codes lovingly and calls for their,
yes,
I swear, man, I'm gonna lose it.
That means I should be able to go in there and say, I want your office, I'm taking over.
Yeah.
I'm gonna write a letter to Trump saying, hey, if that's the case, kick her out. She doesn't count, the rules don't apply. We'll make this 7-2 on everything, Donnie. Yes, Rod. Well, there are times where I have made that argument basically, and the court kind of forces you to make the argument. Your Honor, if I can't make this argument, I'm toast. Sometimes you get forced to make that statement. So here we go. Let's see what he says.
Undoubtedly,
let's see what he says.
Inform this court's decision making. It's quite an astonishing claim to me.
So the black codes are undoubtedly a shameful part of our history, but that doesn't at all mean that this particular law is irrelevant to Second Amendment analysis for two reasons. First, the Solicitor General says correctly, as she did just now, that Louisiana wasn't a state in 1865. The relevant point is what happened in 1868 when Louisiana was admitted to be a state. The Act of June 22nd, 1868 admitted Louisiana as a state. That was the Radical Reconstruction Congress. It examined the Louisiana laws, including this specific statute, and Louisiana was admitted into the Union by the Reconstruction Congress. There were many laws that the Louisiana...
You're not answering the question. The question is, it's an outlier.
So those were good laws?
And you just call it a shameful outlier.
Stop.
I agree with
correct me if I'm wrong, because what I heard him just say is that these laws, these bullshit racist, super racist laws, were part of Louisiana, and Congress accepted Louisiana anyway. So basically, he's saying Congress ratified those laws, and so those are good laws. Is that not basically what he just said?
Nope, and we're gonna get to that here. Let's say that again. Yes.
Undoubtedly a shameful part of our history, but that doesn't at all mean that this particular law is irrelevant to Second Amendment analysis for two reasons.
Even though it completely defies the Constitution in every way, shape, or form and would never be applicable in any other context, Well, here it's still applicable.
First, the Solicitor General says correctly, as she did just now, that Louisiana wasn't a state in 1865. The relevant point is what happened in 1868 when Louisiana was admitted to be a state. The Act of June 22nd, 1868 admitted Louisiana as a state. That was the Radical Reconstruction Congress. It examined the Louisiana laws, including this specific statute, and Louisiana was admitted into the Union by the Reconstruction Congress. There were many laws that the Louisiana...
Yep. Hey, in Louisiana, you could, all those black guys who got lynched. Hey, it's part of our culture. It's part of the heritage.
I cannot believe he just said that. That might be the most shocking argument I've heard this session. That is unbelievable.
I think that's shocking at all. And Chad, if you were wondering what he meant by Louisiana being readmitted, all the states in the Confederacy had to be readmitted to the Union since they left. And they had to come back, but they had to meet requirements, and they had to fulfill Reconstruction. And that meant they had to ratify the 13th and 14th Amendment. And until they did, they were not. They were on provisional status until they admitted they ratified the amendment. So, because Louisiana was a state since 1812. But there was a short period where they were not. Yeah, this is biting the bullet, and this is like putting the whole fucking gun in your mouth.
Yeah,
this is insane.
He's saying that this is because obviously the Congress that admitted Louisiana is also the same Congress that passed the 14th Amendment, right?
Yeah.
So like he's saying that this is ratified.
Hey, you know what? For
Ratification.
birthright citizenship, that's how I want to treat it. How did Louisiana treat birthright citizenship when it got readmitted? Did they allow it or not? Well, it's a part of their culture.
That might be the most shocking argument I've heard. That ratification argument is blowing my mind.
It's fucking insane.
That is some hardcore. How bad do you want to win this gun argument that you're making that argument? That is a hardcore argument. Holy shit.
And the thing is, I wonder, because normally, guys, when you do this, you do prep arguments.
Oh no, there's no way he didn't prep that.
Yeah, no way.
He
knew he was going to have to bite that bullet.
I can't believe he did that.
He knew he knew this argument was coming up. Notice how fast he was finally forced to the corner. Yeah. Like you could tell when it's not prepared. He knew that was going to happen. Even Hawaii's like, yeah, that sounds like a banger. Make the argument, buddy. Does this mean we're getting slaves again? Possibly.
A little bit, man.
Depending on how you interpret the ruling. Autodox, is this looking like a 9-0 or a 6-3? I'm betting 7-2. I bet Kagan's going to be like, okay, yeah, we can't fucking do this.
Kagan can be based every once in a while.
It's not going to be 9-0, though. It's not going to be
If Wishing made it so, but somehow no.
Yeah. But yeah, here we go, guys.
Not answering the Reconstruct specific statute, and Louisiana was admitted into the Union by the Reconstruction Congress. There were many laws that the Louisiana.
You're not answering the question. The question is, it's an outlier, and you just call it a shameful outlier. And I agree with that. And Bruin was supposed to look at the mainstream of our tradition and history, not outlying statutes that were unconstitutional the moment they were passed. And yes, when Louisiana was admitted to the Union.
So Justice Gorsuch, when I said it,
I understand a lot of people like to cite the black codes who promote gun restrictions, who would otherwise, they would be garlic in front of a vampire in front of them. But here they like them, they embrace them, and I'm really interested in why.
So Justice Gorsuch, when I said it, the black codes.
What's that, Kurt?
I'm just saying Gorsuch is right. It's like normally our political friends on the left-hand side of the aisle would run so hard from the black codes as being being racist, horrible, peers of here.
Yes.
And incidentally, they'd be right. But suddenly it's their friend again when it comes to the Second Amendment. I mean, that's it's not exactly principle.
No, he's questioning. He's like, what the fuck are you people doing?
Yeah, what are you I thought you guys thought black codes were bad because the racism is bad.
Yeah.
But now you're like it because it lets you do the Second Amendment thing. So it's like, what are we doing over here? Holy shit.
It's insane, man. It's insane. It's insane.
Were a shameful period. There are parts of the black codes like this particular statute, which were race neutral, which the Congress of the United States, the same Congress that ratified the 14th Amendment, implicitly blessed by admitting Louisiana back in. It didn't treat that with respect to other laws from other states, but it did here. And most importantly, even the opponents of the black codes recognized, as the Sickles General Order says, that you have no right to carry a firearm onto someone's property absent their consent.
Mr. Katyal, wasn't the purpose of the laws?
That was meant so, and guys, if you didn't know this, I didn't think I mentioned it before. After the Civil War, the South was under military dictatorship. There were military governors that were running the states. So General Sickles put out an order, you can't carry arms on another man's land. That was so the whites couldn't start harassing black folks. It wasn't just, oh, you couldn't carry arms around. There was a clear issue there. There was a clear issue about this. EW's like, you carpetbaggers. Yes, Reform Thought is correct. Yes, black codes being race neutral is a very wild take. That's actually pretty fair. It's a pretty fair point. Yes. Yes.
In the post-Reconstruction South that disarmed black people precisely to prevent them from doing what the Second Amendment is designed to protect, which is to defend yourself against attacks. They didn't want that. They wanted to disarm the black population in order to help the Klan terrorize them and law enforcement officers in that period, in that region. They wanted to put them at the mercy of racist law enforcement officers. So is it not the height of irony to cite a law that was enacted for exactly the purpose of preventing someone from exercising the Second Amendment right, to cite this as an example of what?
Yeah.
I mean, the only criticism I have is height of irony is insufficient language. I don't know what I need, but that is too light to describe what's going on here. This is such incredible.
Mm-hmm.
I need more verbiage. This is
the epitome of burning the village to save it.
Pretty much.
He has to win so badly. Hawaii has told him we have to win at all costs. We don't care if you reintroduce. Basically, Hawaii said, I don't care if there's chattel slavery at the end of this. I don't want people carrying guns around.
Yeah, basically.
Yes, that's worth it.
The Second Amendment protects.
So, Justice Alito, we quite agree with you that parts of the black codes were motivated by and had exactly that operation. Our point to you is this consent requirement did not operate that way. Indeed, if anything, it protected black churches and black-owned businesses and the like by insisting on this consent rule. And that is why the radical Reconstruction Congress admitted Louisiana back in. They said no to various laws, but they never did that with respect to this. And this law stayed on the books for a long time. More generally, of course, which obviously for good reason taken all this time on Louisiana. But remember our argument, if we were to get to the historical analogs and the like, we don't think we even need to. But if you got there, you wouldn't just look to Louisiana in 1865. You'd start with New Jersey in 1771.
Well, on Louisiana, in Ramos, on the jury trial right, the question of whether he had a right to a unanimous jury, there were Louisiana and Oregon precedents going way back that allowed non-unanimous juries. And we flatly rejected that historical example for the exact reason that Justice Alito and Justice Gorsuch have been mentioning. Those were rooted in racial prejudice designed to prevent black jurors from having their votes counted on juries in the wake of a decision like Schroeder in 1880. And we just said, no, that's inadmissible to account for that as somehow justifying an exception to the constitutional right. Seems like the same kind of thing here. What's
Justice
different?
Kavanaugh, we just disagree with the idea that that applies to this particular law from Louisiana 1865. But regardless, our tradition goes way back before that. New Jersey in 1771, 1721 Pennsylvania, the law said, quote, "You cannot carry any gun or hunt on the improved or enclosed lands of any plantation." The 1763 New York law, which the Solicitor General only read part of, says that it was unlawful to carry, shoot, or discharge any musket or other firearm whatsoever into any orchard, garden, or other enclosed land whatsoever. And there's other statute after statute. There's no allegation by anyone that those were motivated by any sort of racist concerns or the like. And what they've said is, oh no, that was just limited to poaching. That's just wrong. There's two parts, for example, to the New Jersey law. Part two is about poaching.
And
Part
on
one
those laws, a couple of them that you cite, it seems to me you're approaching the whole analysis upside down from how the court's cases have approached it. The court's cases have started with the text, which declares an individual right. And then in Heller and in Bruin, the court has elaborated on it. Of course, there's, as there are with all rights, as Heller said, some exceptions. But those exceptions, to be recognized, must be historically rooted. Deep tradition, broad tradition, widely recognized, commonly recognized, not isolated examples, particularly not ones from the Black Codes, but even apart from that, not isolated examples. And I just don't see the kind of broad tradition of the regulation here that you see with the other things specified in Heller, for example.
So I agree with some of what you're saying. So I completely agree that the relevant test under Bruin is text. And then the next words you used were as informed by history. And so the question is whether or not there is some sort of right at the framing, whether the right to keep and bear arms was understood, the right to assume an owner's consent to bring arms. That's where we think this case, their case falls apart, because for the first time, you'd be saying, if you accept their invitation, in the absence of any affirmative evidence whatsoever, a commentator, a court, anything that said that there was a right to imply consent, there's just nothing. There is precious zero on that. And here's why it's so important. You heard my friend when he stood up, he said, and under questioning from Justice Barrett, hey, is your rule going to apply to private homes? Because lots of states even today have those, Alaska, in Arkansas and the like. And he's ultimately said, yeah, because the burden shifting, you wouldn't be able to defend the law under the burden shifting of step 2 of Bruin, in which you have to have demonstrated historical analogs and the like. That gets everything undone entirely. I mean, this court has a general rule. Justice Alito wrote about it in Kennedy versus Louisiana, which is when you are coming in to challenge a state law, you bear a heavy presumption that your challenge is invalid, that there's a presumption of good faith and presumption of regularity on the part of the legislature. If you just jump to Bruin step 2 and say, oh, this law deals with guns, therefore the burden flips to the government, then yeah, you're going to have a really difficult time defending laws. Every state is like the ones that deal with gun consent on private homes.
Well, which is why you don't want to get.
Yes, you figured out the point. You figured out the point. Yes, that is the goal. That was the goal of Bruin. It's gonna be tough, as it should be,
because it's a real right, don't you know?
Yeah. Yes.
I mean, it's a constitutional right. It should be kind of hard, like the First Amendment, maybe something like that.
Yes, and it's because people like you, Neil, and all the assholes of the Supreme Court wouldn't just agree and say, yes, strict scrutiny applies. We had to come up with this fucking albatross of a system. Because we couldn't just say strict scrutiny, because we couldn't. So we had to deal with this. And this is a bigger, meatier, and more gnarled and girthier cock that's going up your ass right now. You could have taken the skinnier cock, but no. This big old meaty one that Clarence whipped out is coming up your ass right now. Oh.
You're right,
guys, we're going to catch up to all the other things here too real quick. Yes, Philip is correct. General Dan Sickles is the Donald Trump of the 19th century. He did shoot and kill a man in front of the White House, yes. And he almost lost the Battle of Gettysburg. Because he rushed his corps out to go meet the Confederates and left a massive hole in the lines that almost led to Little Round Top, Big Round Top being isolated, and would have left the entire flank on Cemetery Ridge to get rolled up. Yes, something very, very boneheaded. Thank you for the $10, Philip.
get to step two because it's a lot harder for you at step two. But I think what Justice Kavanaugh is asking, and I have the same question, is how can you avoid step two? Because the text encompasses it. And that leads you to step two, where you have all the difficulties you were just saying.
Because if you read Bruin as only about the text, okay, I agree with you. You could say, well, maybe it's the right to keep and bear arms is implicated by these implied default rules, but it is the text as informed by history. And when you ask yourself, text is informed by history, where has anyone ever said there's a right to presume consent of the owner in the absence of an explicit statement? It just doesn't exist.
That's the second step when you're looking at the history. I mean, I could see history being relevant at the first step if you're talking about what is the meaning of arms, for example. But when you're talking about things that kind of go to what is the core of the right or is it included, and you're talking about history and tradition, I guess I don't see how it's the first step.
Well, I think it's got to be. Otherwise, I think you run into the problem that you've now flipped the burden for every firearms regulation. As long as it deals with guns, then the state has to come in, or the federal.
Pretty much, yeah.
Oh, no!
Kind of like the First Amendment. Yeah, pretty much, yeah.
Yes, it's almost like that's what the point
it's almost like
is.
it's a right. And yeah, you'd have to justify it.
Yes.
Yeah.
Oh, it's going to be real fucking hard.
Yeah, a little bit. Yeah, that's
oh
it.
Well.
You got it, Neil.
Yes.
Government has to come in with an affirmative thing, and we have all sorts of laws.
That's exactly what the cases say.
Thank you.
I mean, I thought that's what the cases say. If it deals with arms, and this is what Heller Part 3 says, then the government comes in and shows there's a historical tradition. And to get ahead of all this, Heller actually went through and specified a number of kinds of regulations that would be permissible because they are so broadly and deeply rooted. At least, I mean, what's wrong with that reading of our precedent?
Because then it would really, as the Everytown brief says, threaten gun regulation more generally in ways this court has so far not reached, because you have all sorts of times in which, like the 922 statute, 11 different categories of things that are singled out as gun regulation. If every single time the state had to defend the burden on each of those things and say, you've got to find, historical analogs, that really does undo, I think, the much more limited nature of the inquiry that Bruin
Mr. Cutell, I thought your answer,
no.
Justice Barrett and Justice Kavanaugh, is that really step one is trying to help us to understand what the scope of the right is.
Correct.
The Second Amendment right. Is it really being implicated here?
Correct.
And so that when you have a situation like this one, in which there is broad consensus, everybody agrees that there is some limit to the Second Amendment right, and you read a case that said that limit was geography, in the sense that you don't have a Second Amendment right to bring your gun onto someone else's private property. They have to consent for you to be able to do that. We have already limited the scope of the Second Amendment right for purposes of this discussion, because we're talking about a right that doesn't just freely exist. So in the Chief Justice's leafleting example, it's similar. Like, I don't see the Second Amendment operating differently than, say, the First Amendment, because in the leafleting example, the reason why you get to go up to the person's door is not because you have a First Amendment right to do that. You get to go up to the First Amendment, the person's door, because there is a custom and tradition of implying the person's consent for you to do that in that situation. That all the states, everybody says, when you come for the purpose of passing a leaflet, we are going to assume, we're going to imply that the owner is allowing you to do that. He doesn't have to put up a sign that says, please come. But it's operating around property rights, not that your First Amendment right is what is getting you onto his property. Similarly, the Second Amendment right is not getting you onto someone's property in this way. If it's a private property, even the property open to the public, it's the implicit consent that many states have allowed that is what is doing the work of allowing you to carry your gun in that gas station. Am I right about that?
That's exactly right. And the one thing I would add is that what I think is doing the work in.
I mean, you could just say it automatically. Am I right? No. I mean,
No. And Adam says, when you break down her words, she uses a lot of words, say nothing because she's stupid. Yeah, well, I mean, yes, sadly, yes. And then Teos is saying for $5, the Seashell case, McKee, they said at the beginning to start the SCOTUS under common law, it's not trespassing on land open to the public until you're told not to. Yeah. That's one of the elements of trespassing typically is you have to be told to leave, especially in public areas. Thank you for the super chat. And also, again, for $10, says the rule of common law with regard to expanses of unchecked and unclosed unenclosed and uncultivated land in this country. Yes. Over these, it is customary to wander, hunt, and fish at will until the owner seems fit to prohibit. And that's very true, chat. In many places, in many states, to keep people off your land, you have to put up signs.
Yep.
And the signs have to follow things. In some states, you have to paint on trees like purple marks or put up signs, and those signs have to be every like 50 feet. There's rules because otherwise people will wander in the woods. It is a very customary thing, yes. It's also kind of like cattle. You must fence out. It's not your obligation to fence in. That's another part of it. Yes, McKee versus Gratz in 1922. Because, yeah, they had black codes in 1922. I guess we can use that one, really. Ag, I'm bouncing around through things. Just like you guys have a million things here. But, yes, for $4.99, Ag says, make Ag's cotton great again. Maca. Thank you, lawyers. Yes. Yes, Ag was working on doing things with cotton plants and trying to reinstitute slavery so there'd be more cotton to pick. Thank you, Ag.
My friend's argument is some sort of insinuation that Hawaii has singled out and is hostile to guns or the Second Amendment and the like.
Yes, they are.
I think it might be a little bit hostile.
96% of the state is
feeling
like
a little
no
hostilely.
touch. Yes, 96% of the state is no touch. Maddie says, how is compelling speech constitutional? It's not. It's not. And yes, that's a fair way to make it the same analogy. This is compelling speech in a way. PSEC is saying purple paint's an alternative. Yes, but depending on where you live, purple paint may not be acceptable. You may have to use signage.
I mean, I wouldn't know what purple paint meant. I mean, I don't know. Was I supposed to know what that meant?
Depending on the state, yes, it's an obligation for you to know.
Well, all right.
Especially in the South, it's a traditional way of doing it.
All right, fair enough.
Yeah.
Guess I missed that memo.
Just don't go wander in the woods.
And I point you to two reasons why that's wrong. Number one, Hawaii has these very same laws about implied consent and changing the default rules for other things besides guns. So 445-115 has it for cards and banners and placards, akin to the example that you're mentioning before. 339-4 is about litter and bringing it on. 291C is about vehicles.
And what you're saying, I think, is that there is no Second Amendment right to assume implicit consent.
Yes.
There is no, to the extent we're talking about, is this about consent? And I think we are, because you don't have a right to go on without consent. Then is the Second Amendment doing work with respect to allowing you to say, I have a constitutional right to assume that I'm allowed to be here? And you're saying they have no case, no history, no nothing that establishes that principle.
That's exactly right. And the other thing I'd point to about this motivation attack by my friend on the other side is that, Hawaii, the legislature took Bruin seriously. This statute's all about making sure the right of Bruin is vindicated. And just last year, for example, Hawaii issued 2,207 concealed permits for firearms.
Banner year, I'm sure. You issued 2,200 permits. You guys are just really doing great work over there.
Look, they're really trying to help everybody do it. They have done a lot to fuck with people in getting permits. It is not the easiest place to do it.
They only denied 119 applications, and the majority of those were denied because people didn't fill out the application in full or they got it out of time.
Thank you, counsel. Justice Thomas?
If you're going to cite the Louisiana Black Codes of 1865, don't you?
Yeah! Oh, no. Here comes the black man with his big black voice. Here comes Uncle Clarence. Oh, I just love how he just cut. You just hear his voice pierce in at this point. Here we go.
If you're going to cite the Louisiana Black Codes of 1865, don't you also have to cite the subsequent adoption of the 14th Amendment that was in part generated because of laws like that?
Right. So that is exactly our point, that the Reconstruction Congress that ratified the 14th Amendment, this is the unusual case in which you have those folks saying effectively Louisiana should come in, and many of the parts of the black codes, including parts that Justice Alito referring to that were racially discriminatory about firearms, were struck from the Louisiana law. But this law stayed in effect. And so, yes, we do think it is relevant history. We don't think our argument depends on it because there's statute after statute from the founding on. And the idea that the number of statutes we've provided isn't enough, I think is very hard to reconcile when you have zero tradition, zero evidence on the other side saying these statutes were problematic. I mean, these statutes were around. You would have thought someone, if this was an infringement on the right to keep and bear arms, would have had a court case, a commentator, anything like what you had in Bruin. You've got none of that.
Well, actually, there was quite, as I said, in my McDonald opinion, quite a bit of discussion of these.
Yeah, that's rough.
Yes, and that's the problem. Neil, he is not a Second Amendment guy. And even if he's anti-Second Amendment, he's not. He's a guy hired to come make an argument. But yes, if you know the Second Amendment, you know about McDonald, and you've read through McDonald, you know it front to back. And yes, Clarence Thomas talks about a lot of these things. And yes, Mexican Vader is right, yes. And here comes Clarence with the steel chair! Oh no! My God! Oh, here he comes.
Sorts of laws and the consideration of some that they thought that the privileges or immunities clause in the 14th Amendment preempted these. That's simply my point.
So, Justice Thomas, I agree with you about what you said there, but I don't think that applied to this specific question, which is private property default rules. I think what the evidence you were talking about there dealt with other aspects of state regulation over firearms.
Justice Alito? Justice Sotomayor?
Three-part question. In one or two sentences, could you finish answering the California point that Justice Gorsuch raised? Number two, finish your list on where else the state of Hawaii has flipped the presumption. You got up to littering and then you were cut off. And then number three, I have never quite understood the court's recent jurisprudence on outliers don't count. I don't know how much outliers mean.
Yeah.
Meaning at the founding, there were 13 states. I don't know how many territories at the time because I don't remember off the top of my head, but there were at least 4 states that had flipped the presumption: New Jersey, New York, Maryland, and Pennsylvania. And then later there was Massachusetts in 1790, at least for a group of islands. And then you don't have just the black codes, you have Oregon and Florida flipping the presumption a little later on. So it seems to me that you can't call all of these laws this many outlaws, outliers. And so the custom and tradition that existed was the license you had, and whether you presumed or didn't presume permission could be flipped, correct?
Correct.
So why don't you answer the other two?
Yeah, so on the California thing, the one thing I would just add to my prior discussion with Justice Gorsuch is just, I think the overall history of what the Hawaii legislature did here was relevant. They weren't trying to attack a second-class right or something like that. They were rather trying to take Bruin seriously by opening up what counts as consent, unlike California, deviating even from the old historical laws like New Jersey in 1771, which required written consent. And I think what did the work in my friend's argument in his opening statement was this idea that 96.4% of Hawaii is now encompassed. You pointed out that dealt with sensitive places, but there is a much more fundamental problem, and it has infected this case from the start. If you read page 1 of his brief, it says, quote, it says 96.4% of the publicly accessible land in Hawaii is impacted by this law, by this law. The map he's got isn't even about Hawaii. It's about one county in Hawaii, not even the most populous county in Hawaii, and it's a map he drew himself. So I just caution the court into saying, because if you read these briefs, it does sound like, oh, the government of Hawaii is out to get guns or something like that. Nothing could be farther from the truth. They've taken
really nothing could be farther from the truth. Really, are you sure?
Yeah.
Really?
So where can I go? Where can't I go, Miss Neil? Where can't I go? Can I go to the beach? No. Can I go here? No. Does it seem like it's almost 90-some%? Well, yeah.
It's only 91%, really. It was off.
Actually, it only feels like 80%. That's just reassuring.
Seriously as the permit statistics I read to you say. With respect to Hawaii singling out firearms, there's statute after statute. I was reading 291, 112, which is that you can't use a vehicle for habitation on private property, quote, without the authorization of the owner. There's also 633.16 that you can't remove shopping carts without the written consent of the owner. There's statute after statute like this, and the amicus brief from the property law professors goes through and says, this is true not just in Hawaii, but in state after state. They flip default rules all the time. Your last question was about outliers. And I think here our most important point is we don't think that there's some sort of mechanistic formula for how many states is enough or anything like that. We do think it's relevant that there are a number of states at the founding that do have this. This court on the sensitive places part of Bruin said legislative assemblies may be a sensitive place. There was only one state in the founding that had that. That was Maryland, and it passed two separate laws 5 years apart during the colonial era. That was enough to count as an analog. We certainly think the much larger number here is enough to count as an analog because these laws actually did the same thing as what the Hawaii law does. It said, for respect to property that is open to the public, like plantations, like premises, like enclosed land. Professor Hartog says that includes seed stores, other retail establishments, akin to the kinds of things that my friend is challenging here. There is historical precedent for all of that. We think that's certainly enough to make this constitutional.
Justice Kagan?
So just on your last point, Mr. Katyal, I took Ms. Harris to be saying with respect to your analogs at Bruin Step 2, that her principal point was, look, it's not about is it about poaching? But the difference between those laws and this law is that those laws were about lands that were closed to the public. And that was her principal point that made that just a different category.
Right. And it just blows off the word improved in the statutes. It's not just about it's not just about fenced land, but improved land. For improved land, the statutes did change the default rule and say you couldn't imply the consent of the owner. And as Professor Hertog said, that applied to stores, it applied to plantations. Indeed, that's the definition of plantations. And it applied to premises, which is another word used in some of these statutes. And so the idea that it didn't apply to these types of things that are just like what my friends are challenging is just wrong.
Okay. And on this, your step one inquiry, which I find interesting and difficult. I mean, I think somebody could say, look, what these consent flipping, default flipping rules do, they do burden the carrying of firearms. And,
Yes.
and that's what they are. And to incorporate the burden into one's understanding of the scope of the right is a kind of category mistake. That it's the burden is supposed to be at step 2, and these are burdens on the carrying of firearms.
So two things. One, factually, we just fundamentally disagree that this burdens firearms. As Justice Alito was saying earlier, if people in Hawaii don't want to have the guns anyway, they're always going to be able to, even under their rule, say, have signs that say no guns allowed. So either way, you could have that burden. The second thing is legally, this court has made clear as day at page 22 of Bruin, you can't ask that burden test. Here's the language. You said, quote, Heller and McDonald expressly rejected the application of any judge empowering interest balancing inquiry that asks whether the statute burdens a protected interest in a way. And so, that which my friend is definitely trying to say, that this burdens the right, that is not a Second Amendment violation. That's going down the road of undue burdens that this court has criticized in a separate number of contexts and saying that's a smokescreen for policy judges' preferences. Rather, the inquiry at Bruin Step 1 has always been text is informed by history. And when you ask yourself, what in the text informed by history this Hawaii law violates, the answer is precious zero. No commentator, no treatise, no court. No one's ever said you have a right to imply consent of the private property owner. And rather, the fundamental tradition, which Justice Sotomayor was saying earlier, that Justice Scalia recognized in the Jardines opinion, is that there's a fundamental right to exclude. And that right to exclude has always meant, at the time of taverns and the like, you can exclude people for violating the terms on which they come in, even if your tavern's open to the public.
Black people, Neil.
Mr. Gorsuch?
Going back to that.
Near as I can tell, the movement to flip the burden with respect to firearms began in the states in 2020. Is that right?
the burden to flip the firearms with laws like this, I think they arose after Bruin. I think that was when this court's decision in Bruin happened, and then laws like the states like Hawaii, in which there was no tradition at all of carrying, had to deal with this question for the first time.
Thank you.
Justice Kavanaugh?
How many states have laws like Hawaii's with respect to firearms on property?
So I think 5 states have enacted those laws just in the few short years since the Bruin decision. I think other states, there's a brief for you from DC saying some other states are considering it. Our point is the Constitution permits both types of rules. It's not constitutionally compelled that you have to use the Hawaii rule. States function as laboratories. They can pick either default rule. Neither is an infringement on the Second Amendment right to keep and bear arms.
Thank you. Justice Barrett? Justice Jackson?
And it's not an indictment necessarily that this arose after Bruin. It was in response to Bruin because Bruin gave rise to the need for clarity about property owners. Once Bruin said you can carry the gun outside of your home, and there was an alternative, well-established principle that private property owners can exclude people, I think the states were trying to make sure that property owners had the opportunity to do that. And that only became necessary once Bruin allowed people to carry their guns anywhere.
That's exactly right.
I mean, it wasn't like they were necessarily trying to keep people from carrying the guns. They were giving property owners the right to exclude by making sure that they were asked, do you want this gun in your store?
Exactly. And I was saying to Justice Gorsuch with respect to California law, Hawaii took it far more seriously. They said, we want to make sure that you have the opportunity to get on the spot oral consent, which is why the gas station hypothetical that the Chief Justice used and the others, it is not an issue under the Hawaii law, because you do have the ability to go and ask for consent, even if there's no postage, no sign one way or the other.
Thank you, counsel. Rebuttal, Mr. Beck?
Your Honor, this, as NRA's amicus brief makes very clear, is a historical tradition of carrying on private property open to the public. This whole legal theory regarding the presumptive ban, default rules, started off the law review article that was published in 2020. And the premise of that law review article is putting in a presumptive ban like Hawaii has would lessen people from carrying. The state of New York adopted that law first, and the governor of New York said the express reason they were doing that was to undermine the Bruin opinion. There's a clear body of evidence here that this was done to undermine Bruin and undermine the Second Amendment right. And thus, this law very clearly implicates the Second Amendment, and the state has simply failed in its burden to justify this law through relatively similar historical analogs. Therefore, this court should rule in our favor.
Thank you, counsel. The case is submitted.
I can't believe how much Hawaii was trying to gaslight me, though. Like I'm offended by that level of gaslighting. Usually, gaslighting's supposed to be more subtle, so you can't quite notice. That's the whole point.
Yeah.
But like, we're not hostile. I mean, unbelievable. Yeah. So yeah, Hawaii deserves to go down in flames, and yeah, they don't. I mean, they're not hostile to Second Amendment, so surely they wouldn't mind if this.
Oh yeah, no, I'm sure that it's all going to work out for Hawaii in the end here.
Yeah.
So.
Well, that was interesting and informative, and more stupid by Hawaii than I even imagined.
Oh my God, that was worse than I mean, I saw the clips and I was like, holy shit! But wow.
And the ratification of
the
Reconstruction Congress was definitely the peak for me of the most batshit crazy argument I've heard today.
The ratification of the antebellum South. It's like,
that was unbelievable. I'm like, wow, that is woof.
Well, we passed a law about it, so it's okay.
Yeah.
Well,
I'm gonna sign off, man. I've enjoyed our time together, but I gotta bounce.
All right, thanks, guys. Kurt on civil law. Are you gonna do anything coming up here?
Not today. I'm tired. I'm probably gonna go to bed pretty soon. We'll see.
All right. See you, Kurt.
Later.
I mean, God, that is. I didn't know they were gonna fucking argue about all that. That is insane. That is insane what we just experienced, chat. Does it mean in Hawaii I can have a whites only store? Basically, yeah. Pretty much. Pretty much. I think that would be a correct. They can't say you can't. Jefferson Post says, so the judicial spirit of aloha is Van Helsing. Yes. Yes, it is. And guys, remember the spirit of aloha where they talked about why you can't have guns? The spirit of aloha, man. And you're saying, so unlike old colonial law like in Massachusetts or Vermont, where public access to private property like woods or beach, unless posted, is the default. Yes. And that is a common thing. That is a traditional thing. Unless you're told, don't go there, you can go there. Squizgar says, where's his neck? Alan Beck does God's work out there, guys. Leave him alone. Leave him alone. EDW Raptor says, has Alan Beck turned his whole body to look around? I don't know. Probably not. He turns around he probably doesn't turn on like Phil. I hate Yankees. Says, wouldn't overturning the Hughes Amendment have better odds of total deregulation? I don't see them overturning the Hughes Amendment. I don't see them overturning the Hughes Amendment. I don't. I would bet against it just on principle. They're not going to allow us to have machine guns. So. Tejas is saying the opinions of FUDs is greater than constitutional rights. Yes, that is pretty much. EDW Raptor said, we're not going to try to tighten the black codes. Well, we found out. And then Drummer78 says, Hawaii was essentially taken over because sugar plantation owners wanted better tariff arrangements. Yes. Yes, it was a corporatist takeover. Tejas is bringing up an argument. They never said states can't secede. It's just the losers can't secede. Well, if you lost, yeah, it's over. It states that secession is legal through revolution, aka winning. Yes, but the idea, I think their point is if you can overthrow the government and take out the Constitution, then you can do whatever you want, which is pretty much how it goes anyway. EDW Raptor says gas stations give implied consent that you can film on your camera until they tell you can't. Correct. They could say no filming on private property. Let's see here. KJ, been a member for 24 months. Thank you. Says happy birthday, Sean. Thank you. Erica Thorpe's been a member for 15 months. Says happy birthday, Sean. Thank you, Erica. Let's see. We brought this up already. The no gun zones at the volcano. Jefferson Post says slavery's back on the menu. Yes, it is, apparently. And then EDW Raptor says Hawaii was discovered by Europeans in 1778. There have been guns there for over 200 years. Yes, the British discovered it. And then Jefferson Post says, so Hawaii is in a consensual non-consent. It's consensual non-consent. It's not consensual non-consensual. It's consensual non-consent play. Yes. Yes. And then Teos Libre again for $5. Thank you. Says, remember, Hawaii didn't exist as a unified entity until King Kamehameha or Kamalea. I don't know. Spam Eater Supreme. That's what we'll call him. Discovered the Second Amendment and united the islands at gunpoint in 1795. Yes. Icebread says, if only DSP was here to relate this to a sandwich shop, then these judges would understand. God. Oh. Well, he would hate them all because he'd be like, look at all your fucking Harvard educations, your book knowledge, and all fancy. Oh my God, he would be going off on them left and right. He's like, you see these snort sacks? You know how I got these snort sacks? Or like, you see this widow's peak? You know how I got this widow's peak? I got Norwooded by my lesbian barber. And she was like, why so straight, Phil? Malcolm Combs for $2 says he wanted Gorsuch to do the needful. Yes, he did. Let's see here. I'm trying to catch up things here. Ammo's Currency for $2 says make Hawaii a territory. Yes. Yes, and that's very true. And then Phil, we covered this. Very correct, Phil. Thank you. Ag biochemist for $4.99. We got that. Make cotton great again. Tejas, the CSEL case, yes. And the rule of common law, yes, is correct. That is a standard of it. The Tejas for $20. Thank you. Thank you. It says Hawaii cited McKee versus Gratz to invoke the Aloha Spirit because SCOTUS said it's up to the state's customs and traditions. If mussels were wild game or belonged to the landowner. That was the issue, not trespassing. See my $10. Yes. But yes, it was about a guy harvesting mussels, chat. But thank you. Jefferson Post says, can we call the Kaga back to Hawaii yet? Remember, there is a ship in the Japanese Navy called the Kaga, and it carries aircraft. EDW Raptor has been a member for 29 months. It says, happy birthday, Sean. Once again, it is not my birthday. And then one more thing here. EDW Raptor says, Kamehameha. Think Dragon Ball when you say it. I don't know if you guys have gotten this. I don't watch Dragon Ball. I never liked Dragon Ball because all you had in Dragon Ball was the guys who were like, ah! They did the thing where they fucking shot things at each other, and then every once in a while they would and there's boom, there's an atomic explosion when they collide, and then every once in a while they're one guy gets tackles the other dude and right into the side of a mountain and some shit. That's every episode of Dragon Ball Z. You can say whatever you want. That is every episode of Dragon Ball Z right there. Prove me wrong. Prove me wrong, chat. A Georgia player got 131 felony charges. Send me that, Ag. Send me that. Send me that. So do you need Hawaii's consent before entering? Yes. Okay. Yes, Dragon Ball gay. I'm too white to enjoy Dragon Ball. Yeah. Yeah, they also have the guy in blackface, so yeah. I don't consume weeb garbage. Yeah, like I said, Girls in Panzer is about it that I've ever watched repeated episodes of. And then Evangelion, but yeah, that's it, really. I watched the whole series of Girls in Panzer. Yeah, I thought it was interesting. Yes, the new Kaga visited and docked at Pearl Harbor in December 2024. Wow. You did need their consent during COVID. Yes, fair enough. Fair enough. Kamehameha. I'm not gonna waste fucking time on this. Fucking conquered. That's all. He's King. I'm gonna call him Ken. That's what I'm gonna call him. Evangelion sucked noodles. Yeah, I mean, it was okay. I mean, wasn't the best thing ever. Man, says, so when do we get a members only, Sean? We're working on that. I thought I'd have a little more time tonight. King gaped. Yes, because that's what happened to him. He got gaped by the white men. Yes, good enough. Enough. Oh. So. Yes, we are gonna do some tonight chat because I got a surprise. Look at this. Look at this. I got this now. And it's got a light on it. So we can try it out. And maybe this will help both of us. Or all of us. I'll be able to see better. And then you guys can see zoomed in. And I could do it all right here. Where I can I could do it in such a way that you guys can see as well, and it's not in an awkward position. So, Tail says, wish me luck again in my California non-residency CW. I'm stuck in Orange County for the next 2 months. I didn't know California did non-resident permits. Good Star Fox mode. Good luck. But no, I didn't know they could do that. I didn't know you could do that. Do I need that for my alone time? No, that's what the tweezers are for. So. He forgot to turn on the camera for at least an hour, huh? Yeah. Well, there you go, chat. I mean, like I said, I know normally, like you guys, sometimes the Supreme Court shit's boring as hell. This was kind of a big deal. I really wanted to see this. I think it tells us a lot about what's going on. I think it was a very important one to get through here. You see that magnifier was not made for the Picatinny rail. Yes, that is correct. But we're going to deal with that here. Looks like Savannah Guthrie's mom really did get abducted in other news, apparently, like that. So that is it for us, though, chat. Yes, the Cali DOJ got felt in September. This is going to be, like I said, 6-3 or 7-2. I have a feeling it'll be 7-2. I think Kagan's going to side with the majority on this and be like, yeah, she's going to be like, I kind of have to do this. She's like, I think she's going to have to admit, like, yeah, I can't fuck around with this here because she's like, I think she understands what's going to happen at that point. That sure wasn't a stream light. Yes, so that's correct. They think it's her son-in-law. Well, it's like, damn, fuck did he do to like get everybody that mad? All right, chat. Well, with that said here, I'm going to switch over the, hold on. All right. Because we got some time tonight. It's only 10:30, so we'll set this for 10:30 on the dot. You see Gorsuch a pot stirrer? Yeah, but he also has a lot of principled opinions. I mean, I will tell you, if you guys want to see Gorsuch go hard in the paint, if there's ever a case or arguments involving Native Americans, he fucking goes hard. Like, like that song, these white ass nibbas go hard as fuck. Oh, he goes hard as fuck. Why are they refusing to take an AWB case? I don't know. Because I can tell you right now, Thomas and Alito want it. Probably Gorsuch. They just can't get a fourth. I don't know. Maybe they're waiting for the right one. I thought Snoke would be a good one in Maryland. Who knows why? Maybe that's the only way they can guarantee Roberts and Barrett is by going slow. Did you hear about the streamer who ran over the Dindu on Kick at a Cybertruck and was flashing a gun on his stream despite Wrigley? No. I mean, like, did Bossman Jack somehow get a Cybertruck, or is it somebody else? Yeah, we're still waiting on Duncan as well. Yeah, there's a bunch of stuff still being listed. Did you hear Brad Carr presented as the chairman of Paul Weiss because of the Epstein ties? No, I did not. And we're going to talk about the Epstein stuff tomorrow night, chat. It'll be interesting. Like, JF Garapy is in there. Call of Duty's listed. Like, there's a good chance you played Call of Duty back in the day. You may have rubbed shoulders with Jeffrey Epstein. Think about that. How crazy that is. You may have kill streaked Jeffrey Epstein back in the day. That would have been based, wouldn't it? Would have been based. But you know what's based? Corey Boatwright for 50 subs. God damn. Woo! Thank you. Thank you so much, Corey, for your support, your generosity. Hot damn. Absolutely. Thank you. Thank you so very much for your support, your generosity. I do appreciate it. I know when everybody out there getting Clavicular, he was waving a Glock. When did Clavicular wave a Glock around? I just knew he ran the guy over, but I didn't know anything else about that. Torgo says, wow, what a sentence. Yeah. Jefferson Post says, what's the chance of Matt getting into the Supreme Court on his cases? Well, I don't know. Have there been any things in it yet? Have they gotten any opinions back? Because that might be interesting, but I don't know. Generally speaking, it's tough to get certiorari. So, but yes, Corey getting him again for 50 subs. Teos saying, speaking of this, isn't it sad the Fifth Circuit felted Hollis, it was Hollis v. Holder, and then Hollis v. Lynch, regarding the only transferable Form 1 machine gun the ATF approved since 1986? That's not true. That's not true. Stephen Stamboulier, I've tried to message him. If you guys watch him, tell him I tried to DM him on Twitter. Ask him what's the best way to get a hold of him, because I'd like to chop it up with him, as the kids say. He proved that's not true. He proved there have been a shitload of well, actually, you're right. The only Form 1 since 1986. Although you probably, if you're including the Stemple M60s as well. But there have been a bunch of transferred, at least, Form 4 machine guns since 1986 the ATF has let happen. I think there may have been 1 or 2 Form 1s in there as well. But yes, Hollis and a couple other guys ran a fast one by the ATF and said, well, it's a trust, so we can build machine guns. And they were like, yeah, cool, go for it. Somebody in the ATF was stamping them with approvals. So these guys made a PSA and Anderson fucking full auto lowers and drilled them out and everything. And then the ATF realized very quickly afterwards, wait, we did what? And they came out and confiscated them, and there was a lawsuit about it. But yes, I remember that on ARFCOM when all that shit went down. So yes, you're technically correct. I think it may have been the only Form 1s, but we found out through his case and the FOIA stuff, a shitload of Form 4s exist since 1986. So technically, I think that means those are Form 1 as well at some point. Yeah, the Fifth Circuit kicked the case because Texas had a state level of a statute. And the Fifth said they didn't believe if the NFA is repealed, Texas would automatically dissolve. But 2 years later, yeah. Yep. Doom Pays, it says, Stuttering John had some choice things to say about my weight. I guess I'm flattered that he had enough brain cells to rub together to make a comment, I guess. I don't know. I'd rather be fat than a fucking troon, so. Because then one of his kids all trooned out. So, anyways. So fucking Jewish says, I love turtles. Yes. Meaning all shockwaves were technically SBSs under the state statute. Yeah. I remember when those came out, and I'm like, how the fuck are those legal? And then you learned about, how technically you can... Mossberg then did the pistol grip shotgun thing, where you could unpistol grip it and all that stuff, and you're like, that's pretty cool. So, yeah. So, yeah, there's a whole line of people that want to nibble on my ball sack, and he can get in line. I'm not gonna let. He doesn't get VIP access. He's gonna have to sit there and let him get hungry for it like everybody else. But yeah, I hope you clip it. I kind of want to see it. I mean, have it's gonna be funny when he has to write fucking checks to Carl and Shuley. That's gonna be the fun part. But once again, Corey Boatwright, 50 subs. Thank you, and it's good to see you, man. Hope you're doing well. Out there. You saw shockwaves in gun stores? Wow, in Massachusetts? Really? Wow. Shout out to Tom from Midnight's Edge. He does that sound effect. Yes, he does. Fun fact, nearly every single Franklin Arms NFA loophole guns were invented in Europe. Really? Oh. Yes, guys. Yeah, well, and yes, Tom is the hardest working guy on YouTube. Tom does a lot of good work. Tom works really hard at all this stuff out there. You guys, if you guys know who Tom is, he's on with Flash all the time. That's who we're talking about, that Tom. Let's see here. How far do we need to rewind for Bon Bon? A long time. To last week. Straight rifling, French pump action shotgun ban loophole, double tapping the trigger to be manually reloaded. Yes, I know about that, double tapping the trigger. It's called the Mars thing, because there's this one channel I used to watch where they showed all those gun reviews, and yeah. So it was weird. They had this VZ58 where the bolt locked open and you pulled the trigger and the bolt went forward, and then you pulled the trigger again and the gun went off. And then the bolt locked back again. Because in Britain, you can't have a semi-auto. So this is their way of getting around it, and then they declared it illegal. They had the same thing, too, where they had they made an AR-15 with a lever you would actuate, kind of like in the safety. And you would drop the lever, and the bolt would re-engage, and you could fire, and you could go bang, click, bang, click, bang, click. And you could go pretty fast. And they also made that illegal because you were shooting now too fast. They had a lot of fucked up, like, the amount of things people try to get around in Britain is actually pretty impressive. But the French had a pump-action shotgun ban. You could buy fucking AR-15s in France, but you can't have a pump-action shotgun? I mean, granted, they're in, like, 222 Remington, but still. That's a little ridiculous. Huh. The latest gimmick is shooting shots on an MP5. Russia did do the shotgun license thing. Oh, okay. I didn't hear about the MP5 shot shell thing, so So Kale said only single tap the thumb. Oh, yeah. Okay, sorry. Yes. Brad says Clyde was 2 hours and 27 minutes ago. Oh, France is cooked. Yes, it is. Yes, it is. So, Eric says UK is weird. I had a fun Switch FN. I failed one of them in Scotland in the late 80s. Wow. Yeah, they had all kinds of cool shit in although they would have called it the SLR, the self-loading rifle. Yeah, they had a lot of cool stuff back then you could get away with. So, all right, chat. I think we're going to wrap this up here. Making sure I didn't miss anything. Nope, I did not. So we got to get over to the model show, guys. You guys are going to be waiting on us over there. So you're making me late, chat, to my own stream. All right, guys, thank you. Like I said, these are the fun ones. I'm glad we did it. I'm glad you guys were here to join me. And we're going to just do a direct over there. Lone Alaskan, yes, he had to play some Command & Conquer Red Alert. Yeah, that was a very deep tweet when you read it. I was like, that really spoke to me. So, all right, chat, with that said, we are going to get ready. Guys, remember, if you're new or you're here for the first time, Thursday night show tomorrow night, 9:30. Savannah Guthrie is going to be something we're talking about. What's going on at the Fulton County election stuff. A judge stealing a couple $100,000. Luigi no longer getting the death penalty. And then a juror in California did speak English and the trial's getting redone. And then also the first of its kind, and I'm working on trying to get the docs and the documents from the journalist that has them. A woman who is 22 now transitioned to a boy when she was in her teens, and she experienced a double mastectomy and puberty blockers. And she realized after that, when she became an adult, she didn't want to transition. It was all just, being a tomboy. So she sued the doctors for medical malpractice, and she just won a $2 million settlement. And we're going to go over, we'll talk about that tomorrow a little bit. We'll go through the documents another night if I can get them. But yeah, the transitioning is kind of on the rocks. It's kind of on the rocks. So, you know what made me jealous? You walked on a gun shop in Morocco, and they had a SPAS 12 with a folding stock for $1,200. Yeah, but now there's like that fake. It's not really a SPAS 12, but it looks like a SPAS 12. That's going to be close enough. Yeah, that was out there at SHOT Show. And then you found out about the cold case trial in Georgia. I heard about that got a little retarded, so we're going to look at that. Yes, Ryan Ralph got sentenced as well. Yes, surprisingly, it's going to be a very long sentence. That's all tomorrow night, guys. We're going to get into it. So just remember, until next time, chat, just because you did it does not mean you're guilty. And apparently that also means you can go into the Supreme Court and advocate for black codes to be used again. I didn't think you could do that, but apparently you can, and it's apparently okay. So keep that in mind, chat. Your dreams are not taken away from you. There might be a day again. So good night, chat. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney.